Here the reasons stated above, this court holds that the resolution passed by the tender committee in its meeting dated 12th declaring so and so is not sustainable, the claim is accordingly set aside. Any consequential order passed by the state is boundary to office. Matters remanded back to the tender committee to take a decision with regard to the remaining term. Uh, dismiss. That yes, sir, I might be allowed to vote against huh? Tomorrow. Tomorrow. What against eviction? Tell them not to vote. Huh? Last day, the DP Kamrup had issued a letter for eviction of the petitioner land. Eviction is not here. Bench five. Bench five, bench five. Bench five. Bench five. But I get to mention that because you lost the picture on 23rd regarding improvement of some clauses. But what happened? Inevitably, the tender has been issued and 1625, 20 is the date. Huh? 20 is the date. That's why my agency is there. That's why I filed the IA, my lord. New IA. Tomorrow, man. New IA. Yes. Okay. Okay, right. On the prayer for adjournment made by Mr. R. P. D. Chowdhury, then a deputy SBI. Who for the other side? Why it is not objected by Mr. A. Das Gupta, then passes for the respondent numbers, private respondents. This is the matter after the vacation. Yes. Mr. Okay, right. Adjournment prayer has been made on behalf of Mr. R. Thakur, who is to undergo surgery. Accordingly, the matter is adjourned. And when I have got consent in the other side, I will have returned the bill to what I want. Return the brief to whom? From the consent. Okay, anyway, then this is Mr. Chandgupta, you are here. You have returned the brief. I actually, as a matter of late, that was not happening. You filed an application under section 73 since 3 years back. But the matter could not be taken up because of the high government speaking sector. No other alternative. So you have returned the brief. Okay, right, Mr. Head. I have the memo. Okay, leaves the matter after the vacation. Yeah, okay. Yes, will say that Gupta appear for the respondent, private respondent. No need. Don't say that also. Don't say that also. Huh? For lifting it, next week, man. When was the file? My lord, no, my lord, it should come. Go to the registry. New, if it's a new IA, okay. New writ petition, okay. Pending matter, go to the registry. Okay. I get to mention item 17, my lord, supplementary link. Inadvertently, my lord, one document is missing. Huh? One document is missing, my lord. I want to file an IA, my lord. Sorry, my lord, additional deputy, can you file 17. Item 17. My lord, can you file? Hello. On the prayer of Mr. S.H. Ikta, Council for the applicant. List the matter on Friday. My pleasure. My prayer for the petition. New matter. Is it a new matter? Huh? New matter or old? Listed before? No. Oh. All right. Yes, at the PP, you had spoken about that other case, that Pranjal's case, Pankaj Bansal's case, Pankaj Bansal's case. And you had said that bail has been denied by coordinate benches of this court by applying that Pankaj Bansal case. I have not found those judgments. I have not found those orders where bail has been denied on the basis of that Pankaj Bansal orders. Wait, that the judgments that you gave me are different. It is great. This order you have not given me at all. You made a submission, but you did not give me a copy. Which para? You don't know. You have given me two, both of them. Okay, Goswami, yes. Where is where is the relevant portion? This other judgment does not, that's it. Patak judgment. There is some other judgment, but if there, all those are not under the subject, contract considered, but after that. There, nowhere has it mentioned, talked about Pankaj Bansal or the requirement of, huh? Not mentioned, only Justice Goswami judgment. Okay, reduce this back. I'll keep this. That's all. Okay. Pleasure. Why? Okay. With the Anjana, Learner counsel for this petition, says that he may be allowed to withdraw the petition with the petition file. Mr. T. Bharat Vahan appears on behalf of R.M. Das, Learner counsel for Auto Response Department. The petition counsel is allowed, this petition is withdrawn from which liberty of speech.
for Sunpura TSK3 that you. One zero six meters.
10. Why not, in this, I am relying on Rule 29 explanation of the rule. When the public place of worship has been clearly defined as a place in a pakka structure with a covered area of more than 200 square feet, which is managed or owned by a registered public trust or a well-established and recognized management committee. Now, my lord, may take up this and annex.
No, no, just show me,
Yes,
just show me which rule?
Rule 289, which is in the Assam excise rules. And that sub-rule 2 clearly mentions the 150-meter requirement for an area falling within the Cow tribe. Rule 289, 2, sub-rule 2, and may I read?
Yes.
No IMFL and beer retail off license or retail on license shall be established in municipal corporation area within a distance of 50 meters, in municipality and town committee area within a distance of 100 meters, in Cow Panchayat or equivalent body area within a distance of 150 meters from any place of public worship or education institution or hospital. Now, my lord, three places, public worship, education institution or hospitals, and no license for retail sale or any other intoxicants that be granted at the site situated within 100 meters from the midpoint of National State Highway. Now, my lord, I have given the diagram, which my lord kindly takes up my big document. The exact page is page 24, the nearest page 20. This is my page.
Here.
The nearest place of public worship 500 meters, the education institute 800 meters. On the left side, there is a box of the diagram. Proposed shop is located 1100 meters from the Satya Temple Road, which is a state highway, and 13,600 meters from NH 115. Now, my lord, the distance will dispute erodes not because of these factors. The authority located to admire one of the worship.
Whatever might have been the, might have been the issue. Now they have come up with a thing that, with a verification report to the effect that your wine shop, proposed wine shop is within the prohibited 150 meters. Now that is a question of fact. Now, if you are disputing that question of fact, I think you'll have to have, you'll have to maybe record evidence. Because
Not the 100 meters first incident. I'm speaking that the place of worship which they have pointed out is at all. Because
so let us see that part, not on the distance.
Not about the distance, that part, my lord, may take it, page 58.
Of?
Annex 50, page 50 of my video.
No, you said that it has to be managed by some
Yes,
institution.
the committee which has established that site, the committee, management committee has given an MOC. My lord, may take it up page 50. I have obtained an MOC from them as well. That is clearly mentioned.
Are they a party here?
No, they are not a partner. I can make them a partner, but I'll just point it out and make them a partner. This subject, no objection from the committee, Hari Kirtan Mandali at Satya Santra, so and so. We, the committee of Hari Kirtan Mandali, do hereby state to solemnly affirm and declare as follows. We have no objection if so and so gets license for wine shop. Further declare if the authority concerned give permission for wine shop open future, we have no objection.
No, Mr. Counsel, it's not the question. It's not the question of they allowing you or not.
They don't have registry.
It's a question of if.
Yes.
If your wine shop is within the prohibited area, they might give you 1,000 crores or to start a wine shop. That does not justify the breaking of the statutory law. That's all.
My question is that they have admitted I don't have registration for the mandal.
Huh?
Paragraph 2, I don't have any registration for the mandal.
I don't know who this person is.
I will put them, I'll make them.
It's
part.
from Hari Kirtan Mandali Secretary. Who is this person
I
also?
don't know, permit as final I will, committee a couple of things. Committee member, there's any, who was that come from my?
Might have changed.
They give a objection.
Correct.
I'll make them a party, I'll file a couple of,
You have to challenge also this document.
yes, madam. I'll file an I, I'll file.
This should be a never ending exercise.
No, because they already, their three bidders are already, have already been rejected, all the three bidders have been rejected. So my lord, they were going to go for fresh tender process. If my eligibility is not taken out at this point in time, I remain eligible for all kinds of come through all things. Therefore, my prayer.
No. The question is, you have to challenge this.
Yes, my lord, I'll file an I. I'll file an I immediately, for simply have a,
No, but then as on day,
Yeah.
this holds the field.
as on they went 6 meters over the field.
Holds the field. This is a finding on fact.
Kind of that, my lord, champion I, liberty for an I file.
You will file, I had to do what?
To amend the prayer portion as well as impede the.
No, this is a question of fact, Mr. Council.
But my lord, on the map, I have annexed the map as well, Google map as well. That is a
This is a finding on fact.
of an institution which is not a public place of worship. If that place, if it is proven that this is a public place of worship managed by a registered trust, then I have no.
No, where does it say that it has to be,
Yes, ma'am.
managed by a trust? Huh?
289 explanation. Rule 289 explanation.
Yes.
Page the one. Public place of worship means a place of public worship, purpose of the government wants to manage or own a registered public trust or a well-established and recognized management firm. I can only make them a party if they can prove that they are registered and owned, established, then my case is. I will not challenge the 150 meter, that won't go away alone. I will not challenge the 150 meter. I will not challenge the.
No, but you see, the thing is that this 150 meter will apply to a public place of worship. Is term as understood in terms of, say, this rule 289. Right? So whether this public place of worship that you're talking about, whether it is having a paka structure with a covered area of more than 200 square feet, and whether it is managed or owned by a public registered public trust, any idea?
And I repeat, where will come the confidence that this person for giving them, where will come the.
Correct, that,
I will sign an I, and in mistakes, how distance is measured, is given clearly an explanation for the distance, how this measured from one this place from to the one. It's clearly given how it's. I will not challenge on the issue of the distance. Only the, I will.
Mr. Council, first of all, where is your case?
Yeah.
That this public trust.
Yeah.
That this public place of worship.
Yeah.
Does not have a paka structure, or that it is not managed by a registered public trust
Out of the NS,
or management committee.
the NOC that is given to me by these people, committee at 858, it itself mentions that they are not registered. I have not registered the Hari Kirtan Mandal.
Is this,
NX, I think the.
please listen. Otherwise, you can go in division bench. You don't want to listen. I'm trying to clarify my doubts and you want to try to stop me from asking you questions. I'll pass the order. later. I'll pass the order. Right, Mister? So clear.
My only distress was I was not being sufficiently clear.
Your problem was you're not allowing me to clarify the issues that I want to clarify.
I don't, I'm. And clarify, my not may seek any clarity.
We'll take it up later. At after half an hour. Yes.
Video the regional stated settlement of village shall be with the respondent of 5 In violation of clause 8 of the tender notice of subdivision laws, I will accordingly settle. The state respondent shall accordingly consider the case of the petitioner for settlement of the petition. Consider the case of the petition for settlement of petition as it you can cover. The state responses shall take a decision on the above direction within period of 15 days from the date of the certificate of the order. Till then, the government may come back to it. Now they have come with the first tender. Can they do it without coming for a review of the petition, review of your worship order?
Let us see the reason given by them.
Hello?
Let us see the reason why they want a fresh tender.
Let me see, page 49. Speaking order. 8, page 49. Next page. 48. Yeah. They will the honorable high court is what I might be taking that test. Compliance with the voted courts standard. The settlement order and deed agreement pertaining to the so and so by service can stand considered limited effect. It is pertaining to note that Himala with the present petitioner has quoted a deed amount of 9 lakh, whereas the current settlement holder Smonali had quoted the so and so 14 lakh. During the initial tendering process of the state petition. Accordingly, it has been resolved to initiate a second round of tender for the. In the light of the above, the field engineer is directed to expeditiously commence the re-tendering process for the Swanko for remaining period. For the period of time to ensure Department of Operation until settlement process is complete. In terms of this order, they have issued a tender next page by page 51. Page 50. Today is the last page. What will you say? For same for remaining period.
What are they said in their affidavit?
In simple, these things, Father, they have finance, yes, everything, paragraph 7. The government to submit that the bid amount quoted by the petitioner was much lower than the previously settled. Does it come now at this stage? Then they're going to that aspect once they worship the
To generate more revenue. What is this bid? Alia? What is your bid amount?
Yeah, in 9 lakh, ours is 9 lakh point of, and for 14 lakhs. And government value is not a 4 lakh. The question is your worship, given a direction. Page of the petition. Then they
Has
could-
it been fit and proper?
Right, one, you does not give them right to go for first tender. They could have come your worship to clarify the matter.
I don't know, we'll have to see that aspect. Because
That is of your worship.
what does the Supreme Court say
Yeah, man.
with regard to this issue?
So with regard to your worship is mentioned, the Supreme Court order of your worship also mentioned in your worship order.
Huh?
Earlier that the matter was written,
Yeah,
but we-
It has said that it can always cancel a tender and call for a retender. Details further.
no, that is the legal one. Once your worship, they have given a finding, man.
But if they want to have more revenue, what is the harm in you?
What is tell them? That can speak about your worship judgment. I am only one
They're
that.
not sitting over myself. They're not sitting over me.
No, your worship, a special order is there.
No, I
They
said
could
that
have come
as
for clarification, man. They could have come for clarification. They could have come for clarification. They could have gone for retendering on them. They have all interest idea also they have given to their factor. Your worship set aside. They are they have made up their mind to because not to allow me.
no, it appears only for generating more revenue.
Might have you know, might have your.
Can you give the same amount as that person?
Yes, yes,
15
madam.
15
They could have
lakhs?
offered me. They could have offered me.
You offer them at 15
Yeah.
lakhs.
They could have offered me.
Maratma Gandhi of the appear.
I will offer. I would,
Yes, they could have offered me like that.
are you,
Yes, but they could have offered.
We
me.
are not going to offer you, but they have.
no, you see, because you are retendering. The reason for your retendering is to generate the revenue, more revenue. And you had allotted the tender to that other person, which has been set aside due to non-fulfillment of certain conditions. Now, if he is willing to match that rate, that bid, then you give it to him.
My lord. May kindly observe and that regarding estimate and stay the tender process.
No, stay,
Today, my-
we'll stay today. We will say that it will be stayed. And that, if they are willing to match, then it should be given to them. They should consider
Yes,
giving.
come on.
After participating the tender process.
No. That tender will go. Tender will go.
My lord, may kindly observe if he is willing to give the.
You are willing to give.
Yes, ma'am. They could have offered me like that. It's type of order.
You could have offered them.
Yeah.
You can offer them.
Lord, may kindly observe.
Okay, right.
Lord, may kindly observe our paragraph from 6 onwards. We have considered this bid and 7 to generate maximum revenue. The-
Correct. You have considered his bid, but you have not offered him the chance to match the bid of that person. The number one.
Find out with them.
Huh? It can be done.
Then Lord, may kindly
It
observe
can be done because your main aim is to
generate maximum.
generate the revenue. And since his bid is still valid, it's only the cost, only the bid. If he's willing to
Give 15 lakhs.
15 lakhs,
Yes. Madam, I think that idea of the, well, in the meantime, also there we get the tender which is going on. Then also we directly be given, so some other person will also come.
no, that should not be open.
Yes.
When is it being opened?
Today.
At 3 p.m. today. You tell them not to open it.
Madam.
Tell them I have passed the order. By lunchtime, you tell them that this has been stopped.
This
That will stop.
new generation not a whisper in the speaking order.
Huh?
Now there's obstacle developed. Even they are bringing this point. Not a
Correct.
single-
Second, the speaking order is.
Right, Mr. H.R.A. Chaudhary, Leonard Senior Counsel for the petitioner, assisted by Mr. A.M. Ahmed. Ms. S.R. M.D. Bora appears for the Transport Department.
Alright.
All the response. The petitioner's case is that pursuant to the order dated 13/5/2025, passed in WPC 6748/2024, wherein the settlement of the Parali Mari Gadova via Barbary Kachari Gaon Nisa Harya ferry service with the respondent number 5 in WPC 6748 of 2024 having been set aside. The respondents were to consider the case of the petitioner for settlement of the ferry service as deemed fit and proper. Next question. The petitioner's counsel subject that the petitioner's bid. How many bidders were there initially? 2, 3.
Four there.
4. You are the second highest.
Yes, the second.
The petitioner's bid being the second highest was however not accepted by the authorities on the ground that the petitioner's bid was only 9,51,786, while the bid of the earlier while the bid of the respondent number 5 in WPC 6748/2024 was 14,50,000. The respondent thus called for a retender. Right, retender notice dated 26/5/2025. wherein the last date of submission of tender is today
Yes, madam. And opening
at,
also.
at
3 p.m.
at
Last date of submission 2 p.m. Tender
at 2 p.m. at 2 p.m.
opening date today also 3 p.m.
Okay. The reason for retendering the settlement of the ferry service had been made on account of the respondent wanting to generate more revenue for the government exchequer. Next paragraph. Mr. H.R.A. Ahmed, Learned Counsel for the, Senior Counsel for the petitioner, that once the bid of the respondent number 5 in WPC 6748 of 2024 had been set aside, the respondents were bound to consider the case of the petition. He submits that the petitioner is in fact willing to match the bid submitted by the respondent number 5 in WPC 6748 of 2024 to the amount of, no, which is rupees
14,50,000.
14,50,000. However, no offer has been made with regard to the same by the state. Next up. Ms. M.D. Bora, that let us pass for the respondent submits that. In view of the submission made by the senior counsel for the petitioner, that the petitioner would match the bid amount.
13 minutes of the date.
No, may consider, can consider. Whatever it is. Would match the bid amount of the respondent number 5 in WPC 6748 of 2020. At rupees, which is now at rupees 14,50,000. The decision with regard to whether the ferry service should be settled with the petitioner would have to be decided by the respondent number
Director. 3 madam.
decided by the respondent number 3. Next. I have further learned for the part. The fact of the case is that the petitioner being agreed with the settlement of the ferry service with the respondent number 5 on account of the respondent number 5 not having submitted his tender document in terms of the clause 7 and in terms of clause 7 and 8 of the NIT dated 8/2/2020 and put the same to challenge in WPC 6748 of 2020. This court thereafter allowed the writ petition, allowed WPC 6748 of 2020 by holding that the respondent number 5 could not have been settled with the, no, the ferry service could not have been settled with the respondent number 5. As the terms and conditions of the NIT dated 8/2/2024 had been violated. This court Right, order dated 13/5/2025, passed in WPC 6748 of 2025. Accordingly, directed the respondents to consider the case of the petitioner for settlement of the petition. To submit that. It pursuant to the order dated 13/5/2025, passed in WPC 6748 of 2025. The settlement of the ferry service with the respondent number 5 was cancelled by the state. On considering the fact that the bid of the respondent number 5 was 14,50,000, while the petitioner's bid was 9,51,786. The respondent decided to re-tender the ferry service, the settlement of the ferry service, to generate more revenue. As they were not satisfied with the bid submitted by the petitioner. This court is now next term. On considering all the above, this court is of the view that as the petitioner was the second highest bidder after the respondent number 5. In relation to the NIT dated 8/2/24. The respondents could have offered settlement of the ferry service for the remaining period of the season to the petitioner at the bid amount quoted by the respondent number 5. As the senior counsel for the petitioner has categorically stated that the petitioner is willing to match the bid amount quoted by the respondent number 5 in WPC 6748 of 2024. Now, this court is of the view that the state respondent should offer the settlement of the ferry service to the petitioner at the rate of rupees 14,50,000. Thereafter, the settlement can be finalized if all the other terms and conditions of the NIT dated 8/2/2020 are complied. The respondents are accordingly directed offered to the petitioner settlement of the ferry service at the rate of rupees 14,50,000 for the remainder of the fee. And thereafter, within a period of 2 weeks from the date of receipt of a copy of this report.
1 week motivation.
In
I am to offer watch list.
No, you are not to offer. They will offer you.
So within 1 week, what kind of already gone like.
They will offer. You will offer. Now in the flood season, you will not be able to. The ferry service will not work.
1 week we offer and another 1 week
Ah.
we accept our offer.
He will do it in 1 day. Okay, 1 week.
You cannot do- you kindly order
Full stop,
Page 15 is retender.
26
full
by
stop.
26.
5
In view of the reinstated above,
Page 5
in view of the reinstated above, this court is of the view that
5
page 51.
51. What
See,
company was good fine?
In view of the reinstated above, this court is of the view that there is no requirement of issuing.
What company?
There's no requirement of going ahead with the re-tender notice dated 26/5/2020,
Reject our opponent.
which is which shall be kept in suspended, which shall be suspended till a final decision is taken with regard to settlement of this credit service at the rate of rupees 14,50,0.
In favor of the petition.
In favor of the petition.
Public.
In this matter, we have filed our objection today morning.
So you find it?
Yes, lawsuit, we filed it. And,
They are ready.
it's not on record, the objection, we're filing it. We're
You
filing.
are filing it or you find it? Maybe
It was filed at 10:30, the filing was 10:30, so now.
if you have filed it, you have filed it. If you have not filed it,
It's
you have not
fine,
filed.
it's fine.
So y'all are ready or not?
Yes, my lord. It's very simple, my lord. Small issue.
You are for the petitioner,
I'm for the petition.
lead petitioner.
I have
In
filed
fact, instead of the IA, it's a
We'll dispose the entire issue.
it's a very small issue, but then for that matter, the records will be made.
Why?
Because what has happened here,
Okay, because the methodology,
criteria was changed,
according to you, the methodology for awarding the contract has been changed.
was changed in the midway. There
And
was a-
according to them, it's not changed.
No, it's changed. They also admit now they've changed, but they say it was not changed by the chairman, but by the tender evaluation committee. So the admission is, it was changed between. And why it was changed, the criteria is not been given, it is not been given.
But in the initial NIP,
There was no
What?
methodology.
there's no methodology.
Then what happened was, two of us were became L1. Then they adopted the methodology, not communicated to us. Be that as it may. Methodology was in place. Now suddenly the methodology was changed by a handwritten note by saying, let us now reverse it totally. And why was the reversion done? Work order, 40% allotment of mark, 20% was financial. They completely changed.
Why
the
don't
order.
you, why
So
don't
that
you,
we get.
why don't you issue a fresh tender?
Kindly see, my lord. Kindly see
Who is for
the.
who is for the authority? Why don't you issue a fresh tender? That
No, my
will
lord.
be.
Kindly see that document, my lord. If you
Anyway,
don't-
no, the record will have to be necessary.
I have work order, double his work orders.
Because that's
So
not
they have also
necessary to change, my lord, because it is that, as per the NIT, my lord, the tender of that quote, plus minus 10%. So normally, my lord, everybody quotes minus 10%. So therefore, there are certain, in respect of many contracts, my lord, there were more than one L1, my lord. More than one L1, my lord. Because everybody quotes minus
Correct,
10%. So for that purpose, my lord, they have adopted a methodology. And my lord, as alleged by the petitioner, the chairman was not part of that methodology. You know, kindly see only one document, my lord, of my IA, my lord. Only one document, my lord.
Their ground,
My lord,
Just a minute, one at a time.
no, because he's submitting what I was submitting only. The
page
different.
11, my lord. Page 11 of my IA, my lord.
Yes, yes.
Page 11. His allegation is that the chairman has changed the methodology, my lord. My lord. But here, kindly see, my lord. Because initially, NSR proposed marking criteria for evaluation of eligible bidders in cases with multiple L1 bidders. So here, it was the methodology that for the class, 40% will be awarded, for work order, 40% will be awarded, and for financial turnover, 20% will be awarded. Then, my lord, the committee, my lord, they endorsed a note to the chairman in municipal court. So they endorsed a note, my lord. The scope for financial turnover may be taken as 40% and scope for work order may be considered as 20%. If majority agrees, and this was endorsed by the committee consisting of.
You see, this earlier methodology that has been applied, was it being used in other contracts?
Yes, my lord. In
The earlier one,
Yes, my lord.
then
No, my lord. That changed methodology. Earlier not earlier one. That
Why they
methodology-
change?
what do you mean?
Why they change?
Yes or no, which one?
No,
No.
that methodology.
So that is why we will need the record.
The big municipality board will be in a much better position to answer that question.
Let him in the record.
So why they change? That is the question.
Yes,
Change is
yes,
because they have now-
Mr. Council. Yes. Huh?
not the team paper, but they are governed.
I don't know.
Or any
Huh?
other day.
Monday, too many. I think,
Not Monday, Monday I'll not be there.
Or at least Friday, madam.
Friday also.
what do you think? You're the only case in town now. We've got 52,000 cases here in the Guwahati High Court.
Next week, after Monday, anything. Next week after Monday.
You see, whatever, I want to ask you a question. Are you ready for the question? You're ready? Now, this methodology used for awarding contracts where there are more than one L1. What was the methodology used earlier?
With the percentage I gave, I guess. Yes, this is. So we can ask them to first.
I think we're not on the same page. You are in page 1, I am somewhere in page 50. This is the very purpose of this methodology being made. Is due to the fact that there have been many L1 in various other contracts. So it's not the first time. What are you talking about? This is the first time. That's right. No. So because the record may pertain to only this contract. So we will need the
Whether universally it has been followed or not.
yes. What was the methodology used earlier? The president.
We also
there were 20 of the
Huh? Whatever.
Also other
Hey, you wait. You have got nothing to say. They are more important than you just have to. Yes. They are supposed to answer, not you.
the methodology otherwise had to be disclosed, as the Supreme Court of Justice Educom had said. They have not disclosed, number one. But we are agreeing that they have to adopt the methodology. They have adopted the methodology. Suddenly, midway, changing it by a handwritten note, that vision or the reason for that has also been seen as to what is in their office note, that they wanted to change it.
Okay, right. In the right in the in the I, right? Heard Mr. A. Sharma, counsel for the writ petition. Also heard Mr. A. Gupta. A. Gupta for respondent number 3 and 4. Mr. R. K. Tarukdar for R. Tarukdar for 1 and 2. And Mr. D. Bora for respondent number 5. The grievance of the writ petitioner is that the methodology for awarding the contract has been changed midway during the selection process.
Two grounds, not been disclosed, first of all, and the second is, even not been disclosed again. Good, sir.
And comma, keeping in view the fact that the petition and the respondent number 5 were both L1. The 6. Who is 5?
I read the official.
Huh?
Official.
Then you're for whom? 3, 4. Who's for 5?
5 is the executive officer, being municipal officer.
You'll appear for him also. You should have said earlier 3, 4, and 5. 3, 4, and 5. Huh? And we borrow for 6. Okay. Next. The respondents council can produce the record, official record, to see the reason for changing the methodology for awarding contract midway. This court would also have to see the methodology used for awarding contract in similar cases. This is a matter on when? Tuesday? Tuesday.
Can it be 25th, the next day, 25th? 24th, I may have some difficulty reaching, so I'll be out of sync on the argument. 25th.
No guarantee what you get.
Oblige. Interim order the month.
Interim order is for this.
Oblige.
Oblige.
That is the last appellate matter is accepted for what for the case. Then the suspension order is gone up. Yes, the precedent action I have received that which indicates that suspension order has been dropped.
Under the matter,
Facing, facing.
Mr.
And
N. Hawk appeared for the petitioner, while Mr. R. Talukdar appeared for
Response number 2 and 3.
point number 2 and
It can already responded. Already.
appeared for the response. Next, Mr. R. Talukdar has submitted letter dated 10/6/25 issued by the Deputy Director, in charge FPD and CA, Nalbari, which is to the effect that the suspension order of the petitioner's FP shop has been withdrawn by DC Nalbari order number NS-95/2019/104 dated 20/10/20. Next. In view of the above letter dated 10/6/2025, the writ petition has become in fact. The letter dated 10/6/25 issued by the Deputy Director in charge, FPD and CA Nalbari, I see that, is made a part of the record and marked as an issue. The writ petition is accordingly closed as in fact.
Okay. Market matter. Already deposited the amount much demanded. But we have not yet been allotted the room money. The petitioner was the authority. But they denied to hand over the room. They find out the hand over the room, unauthorized parcel money.
Mr. Council, yeah, I think you have seen the affidavit
Yes, madam. I also
of the respondents number 2, 3, and 4,
for 10 affidavit, madam.
and all of them have denied taking money.
Yes.
Then what remains?
Yes, madam. I submitted my reply, madam, for the document.
Yeah, you go to the civil court. You've got the substantive documents or not, you've got to prove it before them. This is a question of fact.
Yes. Who take the amount in their account, my. Their account.
Where?
Yes, madam, can you see my affidavit? My affidavit, madam. I connect. Okay. My lord. 42, my lord. 41, 42. Their account, my lord.
You see, Mr. Council, according to you, you had deposited 80,000.
Yes,
50 plus 30.
my.
Where is that deposit of 30,000?
30,000, my lord, I have not, any document, my lord, because they police issue the receipt letter of the.
Those are questions of
I say
fact.
that I made submission, my receipt, yes.
Those are questions of fact.
50,000 is.
Where is the statement of account from the bank?
my lord. And they deposited the amount and they also acknowledge the receipt of the amount money. They acknowledge it.
No, Mr. Council, these are,
Yes, my lord, can we see?
please understand one thing. A check can always be made which can bounce, okay? The issue is whether there has been a transaction of money from your account to their account. For that, a statement of account can be taken from the bank, signed by the manager, showing that from your account to a particular account, the amount has gone. And then you will have to also prove that the account to which it has gone belongs to the respondent. There's nothing is here. And that,
Sometime when.
No, no.
I will deposit it.
just a minute, that is only with respect to 50,000.
Yes,
What about with respect to 30,000? There's nothing here.
yes, my lord. Have to put it to my equity government. But they have not, given the. Well,
If they have,
sometime
you see, Mr.
I will submit the statement, my lord. Sorry.
No, please listen to one thing. If they have not given you the receipt, now your statement will not do for the simple reason that they have denied taking any money from you. Now, am I going to decide? Am I going to decide that issue by considering whether you look very truthful or he look very ugly or what? It cannot be. There has to be some facts, some evidence. This is a court of law. This is not a court of facts. Court of facts is the civil court. You go there where you can take evidence.
Sometime,
You're not
bank.
no point. Waste of time.
Whether he is the government of the thing, 40 years back, man. He occupied the land, my lord, and he promised to, allot this one room, my lord. Each, my lord, but they are denied. last-
He is the settlement holder for since 40 years back.
Yep.
That means how old will he be now?
40 years, my lord.
So how old will he be? At least 40, minimum 40.
Yes.
See if he was settlement holder since childhood
My lord.
or since birth.
No, my lord. The Father was there. And
Well,
like I said, I read my special. Then the petitioner father was there, now the petitioner. Okay, no.
Where is your statement? Let us see.
My lord.
The petitioners are doing their business on the plot Vita situated at Prince and by paying since 35 years back.
Yeah.
Petitioner, not your father.
My lord, I know, give me 1 minute. There, my lord.
Nowhere.
There, my lord, there, my lord.
The three months. There it is. That the petitioner respectfully beg to state that initially they and their predecessors, along with other parties, other petty businessmen, took the opportunities to have a plot adjacent to the market. It's not inside, adjacent to the market, run by the Doboka Gaon Panchayat. Now, Lordship, their reply page number 37, they had annexed one, my lord, permission, license, my lord, which was issued in the year 1983. By paragraph 3, my lord, if we read this, my lord, this was issued for a shop which was adjacent to the market, not inside the market.
Page 33 of the repetition,
37 of the reply.
37 of the reply. Of the reply, of the reply. That is- of the reply. It's the, this is 1/10/1983.
Yes. This is the, now paragraph 3,
This
the-
permission, where is the paragraph?
paragraph 3 of the repetition, my lord, mainly.
Okay.
I've just read it. They are admitting, my lord, their predecessors stopped were outside the market.
Now
They
they
were
are,
annexing those markets license in the
They-
reply.
they are. And this is under Sri Kamal Haldar.
Order of the petition number 2.
So where is petition number 1? It's got nothing to do with. The prayer has been issued within the jurisdiction of Nagam Mahakuma Parishad. Now what is
That is
this?
a normal license issued to all the soft establishments under the Mahakuma. Normal license.
Just a minute.
No specific place.
Disturbing, let him speak. He didn't disturb you. So this page 37.
Yes.
Is,
Maybe issued to his petition numbers to his fathers.
petitioner number 2, it has been
Father.
issued to.
Yes.
Sri Kamal Haldar. Wait,
Yes.
let me see. Kamal
Yes,
Haldar.
Kamal is the, I have taken my lord,
No.
father of the.
The father of, no. This is Siju Haldar.
This
Who
was
is-
just father, my lord.
No. Siju Haldar is not here. There's no name. Come to page
My lord,
37.
Sidhu Haldar's father name is Kamal Haldar, page
Ah.
number 2.
So this is the brother of Kamal Haldar. Oh,
My lord, Kamal Haldar is the father of the.
okay. So Siju Haldar is the son of Kamal Haldar.
Yes. By showing this license, my lord, I want to submit, my lord, that paragraph number 3 of the replication is saying that their predecessors are doing business outside the market, not inside the market.
Ah,
They are admitting.
so yes, so
They
therefore,
don't have any right.
there's a right.
My lord, I clear the matter, man. Give me 1 minute, my lord. Earlier, my lord, the Panchayat market is not whole area of principal. Now it's
You
come
see,
under the
you see-
municipality.
You see, Mr. Coulter, whatever you do, now whether it was within the market area, outside the market area, whether you want to produce a statement of account, whether those statement of accounts are true or false, these will all require evidence.
My lord, I will see. Municipality took over the
You-
market along with all the municipality areas of Doboka town.
You see,
Now,
if because no certificate has been issued to you. This has been issued to this Kamal Haldar.
yes, my
And-
father,
Huh?
Kamal Haldar is the father of the petition number 2.
Correct. So, but then let Kamal Haldar come. Where is Kamal Haldar giving you the authority to come to this court? Show me where is the authority?
My lord.
Where is the authority given by Kamal Haldar to you to come to this court on his behalf?
My lord,
You are not the license holder. The license holder is Kamal Haldar. You are Sijul Haldar.
my lord, can we see? Kamal Haldar is now. Yes, sir.
Now in sick bed. Where have you said that now in sick bed?
My lord, that's why my lord.
You don't make up cases. Don't.
Time, my lord,
Alright. Mr. AJ, learned counsel for the petition. Also has Mr. L. Zafar, learned counsel for the two and Mr. R. Talukdar appears for,
Three and four.
appears for.
Fine.
One. The petitioner's case is that they and the case is that they and the predecessor, along with other businessmen, were given a plot bracket beta adjacent to the market run by the Doboka Town Panchayat and have been doing their small business therein. The petitioner thereafter developed their plot under their occupation and constructed temporary huts for their business. The petitioners were also paying yearly rent to the authorized lessee of the Doboka Town Permit against issuance of it. The petitioners stated that their betas were allotted numbers 7 and 5 respectively by the Doboka Town Permit. In the year 2017, the Doboka Municipal Board decided to construct RTC head in the, what market is this? In the
Community market.
in the market area. For letting out to the existing Vita holder in consideration of rupees 50,000 only as security money. Next one, the petitioner thereafter deposited rupees 50,000 to the Doboka Municipal Board. And the same was acknowledged by the Doboka Municipal Board by way of a receipt dated 29/5/2000. The petitioners were also made to deposit rupees 30,000. However, they have not been given any receipt for the rupees 30,000. However, no, the respondents thereafter did not allot the petitioners any vita as had been promised. and despite payment of the fee, 80,000. Next. Now, continue. In this respect, the petitioner's counsel has relied upon no, in this, no, don't say in this perspective, this is the petitioner's, the petitioner's counsel has brought to the notice of the court the Dabaka Town Panchayat permission letter plus license dated 10/1/1996, 1986, 10/1/1986, issued to Shri Kamal Haldar, son of Shri Gopal Haldar, resident of Doboka Gaon Panchayat, Muza Jamuna Mukh. He accordingly submits that a direction should be issued to the respondent number 2, 3, and 4 to allot an RCC at each to the petitioners in the newly constructed market complex under the Doboka Municipal Park to allow them to continue with their business. Next part. The counsel for the respondent, on the other hand, complains that they deny that the petitioners were paying revenue since for the last 35 years against any people. Further, the Daboka Municipal Board has never demanded any amount from the petitioners for handing over possession of the market share. Further, no vita was allotted to the petition, and that there is no regular tax collection available. They also submit that para 3 of the writ petition clearly shows that the petitioners were not running their business in the market, but in a plot of land adjacent to the market. They submit that as the petitioner claim for allotment of a vita is based on disputed questions of fact. The petitioner should oppose the civil court. Next one, I have heard the learned of. As can be seen from the affidavit in a position filed by the respondents number 2, 3, and 4 separately, they have all denied that the petitioners have been paying revenue for the last 35 years against any people. It has also been stated that there is no record of payment of any revenue available in the office. There is no record of any regular tax collection available in the office. Further, no allotment order with respect to visas is in the office before. Further, the Daboka Municipal Board has not demanded any amount from the petitioners for handing over the possession of the market share to the petitioner. All the above governments made by the respondents in their affidavit, affidavit in a position clearly goes to show that there are disputed questions of that. Which would require the matter to be agitated before a civil court, wherein evidence can be required. But what is your reply? Same thing. Before that, you just write one thing. Though the petitioner has submitted, has annexed a copy of the check dated 18/5/2017, 2017, which is an alleged payment of rupees 50,000 to the Viboka town committee. There is nothing, there is no statement of account next to show that any amount has been transferred from the account of the petitioners to the account of the Viboka town committee. Further, there is no record of payment of rupees 30,000, the additional 30,000 by the petition to the respondent. What have I said? Where the real state of this court is of the view that the petitioner should approach the manner, the civil court of redressal of his grievance as evidence is required to be adduced. The writ petition the following. Yes, who the parent? And you have admitted the amount. In the time heard Mr. S. Fajay, learned counsel for the petitioner, who submit that the petitioner had provided a minibus bearing registration number AS01 GC 5462 from 2020, from the year 2020 to 2020 for hire to the respondent authority. Though the petitioner had submitted his bill amount of rupees 28,66,632 for hire charges, for the hiring charges of his vehicle from 1/7/2020 to 31/12/2020. The petitioner's bill has not been paid by the respondent authority. Mr. R. Talukdar, learned counsel for this. All the respondents submit that that the respondents have verified the claim of the petitioner and they have and it has been found that the petitioner is liable to be paid. He is his 9 bills amounting to rupees 28,66,62. However, no, as and when sanction of the amount is given by the sanctioning authority, the fund will, the funds would, and funds are allotted for payment to the petitioner. The amount paid by the petitioner would be fixed. But I have heard the land count for the fund. The affidavit filed by the respondent number 3 shows that the respondents have admitted that they are liable to pay rupees 28,66,62 to the petitioner as hiring charges for his vehicle. Accordingly, in the respondents having admitted their dues with respect to the amount paid by the petitioner, the respondents are directed to give the necessary sanction and allot funds to the petitioner for payment. The entire exercise to be concluded within a period of 4 months. 5 years. With 3 months from the date of receipt of a certified copy. For payment to the petitioner. That's the difference.
Regarding the cardiac monitor fee, that I was disqualified on a technical aspect because of non-submission of documents.
Yes, sir. The petitioner has put to share the receipt. Yes.
Technical bit is structured by the rejected on this block. However, when the valuation of statement, I think state line, and the clarification of the all the other substitutes were just positive. Now, when the being applied, so giving a, so previously there was 3.74, so the charge.
So you see, wait, the technical base committee sat on 21 to 25, correct?
Yes. Technical bit by the
Yes, so minus was made on 21 to 25. Now, after the petitioner's bid was disqualified, along with two other persons, they were asked for a clarification. No, prior to that, prior to the court, other after the court. So clarification was prior to the. Then, anyway, so after this, technical bid evaluation phase, the petitioner submitted a representation. And then you made a reply to the petitioner's representation.
It's 110.
Where you held that the rejected bidder's average annual turnover from CA, the submitted document is not properly addressed. And that the CA signature makes it not. So according to the petitioner, the 6 reasons that were earlier there for rejecting the bid has come down to what? And,
What why I'm saying is, a particular technical field is often done. There are things built with functional minus of the technical feature, extension of the total feature, reflected in the minus. The reason is taken. That decision we have already uploaded. That on fixed ground, we have to do it.
that has been uploaded.
It is not uploaded. Against that, he submitted the representation. There is a particular portal, there is a particular part where you can apply, there is a procedure. And we are supposed to consider it in there and here are reason. But that this doesn't mean that when those 6 ground goes by making one minus particular ground. Because if you are to review this minus entire minus, there will have to be again a minus minus. You have to allow that instead of 6, we are now rejecting on 5. That is not there.
Okay.
So whatever
Now you have to that
6 ground.
6 grounds. And now this reply that they have made to the representation, is it a part of the 6
One
ground?
of them,
Is it a part of the 6 ground?
yeah, this is a part of it.
Part of which?
Yes, responsibility pays to the offender. That's right.
Yes.
Responsibility when here it is at the top progressive enterprise, there is a deputy cutter. Responsibility for offenders 24 to 2025. At 11:58. And the status is disqualified. Reserve to number 1, with the return service submit average effort transfer.
And what about the reply to his representation? Which page is that?
210.
It's representation, penalty plus.
Now this-
Description.
Yes.
There may not text representation paper.
So now this reason that is provided at page 210, is it reflected in page 207? This page 210, the reason given is 210. Is it reflected in those 1 to 6?
Yes.
Where? Where?
So these are the grounds.
I think serial number 1 has some semblance of
Okay.
similarity.
Same way.
Bidder did not submit average annual turnover,
Okay.
but then the language in the rejection is
Okay, so this
It
part
talks-
one.
Yeah.
Okay, so
there are two
now,
aspects.
ah,
One is that annual average turnover. That is one sort of a audited balance sheet kind of a document. And the CA certifying is certifying the entire thing. So what they say the rejection is about the CA certificate. The rejection ground, otherwise in my disqualification is I have not submitted that balance, that audited average annual turnover. And the rejection is after my representation considered, bidder's average annual turnover from CA submitted document is not properly addressed and lacks CA signature. And the answer to this is clause 19, which clause 19 says alternately, you can submit the annual average turnover or the CA certificate certifying the same. And I have produced both the documents.
what about 2, 3, 4, 5, all this?
All this I have submitted in my representation also, and I have the documents in my hand also. They were all submitted on.
That is the question of fact.
It's a question of just looking at the portal.
Portal.
Yeah, the technical officials of the petitioner who have uploaded are there. They have shown me in the website now only, every document.
True.
Yeah.
Ground number two, says bidder do not submit details of skilled and trained service engineer based on account. Because ground number two for rejection at phase 207.
Details of skilled and trained services engineers based on the top, yes?
Now, my lord, to substantially, subsequently, the petitioner has submitted one document at phase two. Good part of our estimate.
True.
Yes.
Ah,
Possible C, my lord, please states. We hereby confirm that we do have skilled and trained service engineer based on Assam to preserve any types of technical service support on time. Details are given below. When the possible see the date at the bottom. 24/2/2025.
and what was the last date of submission of bid?
It was on the technical bid was open on 11/2. So it was prior to that, my lord.
Technical bid on
11/2.
11 to 25.
25.
So this has been submitted after technical.
May I submit my reply out against this point exactly before it goes ahead? The first point, what they are saying is, it is not a requirement under the NIT terms of conduct, number one. Page 96, 196, it is not a requirement under the.
Okay,
And
that's,
second,
let's,
just to clarify,
No, I will.
let's,
Why we have paid page 199, 192 of the.
one by one, it can be handled, therefore I was like trying to give a reply.
okay, maybe we should go one by one.
Or else it becomes,
Now, my lord, propose the point number one is.
Now, point number one is,
reply against that.
point number one is the
Emergency and well,
207.
207.
207. I think they are going to take time. Okay.
I think the most easiest way,
Let's,
if
yes.
I may submit is that everything is uploaded in the website. The technical persons are there and they are showing me the paper, all PDF files are there. If it can be just seen by another friend, clarifications are just available there itself. Why we are exercising this? They are saying it's there. and-
So why don't you all, four of you all go outside, have chai, have paratha, have
I.
chow,
Okay,
whatever. And then after you all come to a finding that, yes, you all have decided this way, you all come and tell me your result.
The only thing is that they are saying,
Either I
everything
can
is
do some other work then.
only thing, I'm just trying to simplify the issue by saying,
No,
they are saying everything is there. And all PDF files, I have seen all the PDF files. I just need to show my understand that these are the documents in your own website, these documents are available. Why are things not there? That's what
One
they don't
document I have just now placed there.
no,
Or
So-
they will approach the office of the medical director.
no. First of all, let us go to the NIT and let us see where these six requirements are there. Let us go to the NIT, where is
So, Lord, we will see page 191. The first point, madam.
191?
Yes, regarding the turnover point of cost 90. Page 190, page 190.
90 or 91?
191.
Yeah, 191. It was
90.
yes.
Bidder turnover criteria. The minimum average annual financial turnover of the bidder during the last 3 years, ending on 31st of March of the previous financial year, which is as indicated in the bid document. Documentary evidence in the form of certified audited balance sheet of relevant year.
Or-
Balance sheet or of relevant year or as a certificate of the certified accountant, cost accountant indicating the turnover details of the relevant year shall be uploaded with the bid. Here petitioner has uploaded both. I am checking personally, madam.
So he complied.
Even if you hold that, my lord, that certificate, there is some flaw in the certificate. But my lord, it's balance sheet are there. Balance sheet are there.
And that's the ground I was rejected. The ground I was rejected.
Ground number two. Now let us talk to ground.
Okay, so ground number one so is
I
gone.
think, my lord, yes.
You concede
Oh, no, my lord, we will not.
1-0. That means Round number 110,
And
correct?
and
Okay, I'm writing that
no, no,
10.
no,
My lord, private respondent. So he-
Yes, sir. Who are you?
he is the one who is got the.
You are not the technical bid committee.
And
You can just sit down, relax. You are not the authority to decide whether his tender it should be qualified or not qualified. That is not your job. No, you see, let them decide. Ah.
But then, of course,
But then that will have to be decided by them, not by you.
but in this.
No. Why should I decide? Why should the court decide? This is a tender matter. The requirement of a tender notice has to be decided by the authorities. Only if it is perverse or very arbitrary that no man in his right mind would think can be done, that we can interfere. Otherwise, why should we interfere?
and the
But
tender
it-
even
it-
if the committee.
I would prefer that way, there is no doubt. If I don't know, this is what has helped, my lord. This is the precise reason why, my lord, the private responses are to be made fast. They are the one technically, my lord, so advanced and they know about the entire issue. They can point out each other's fault. It is there.
No, but then they can point out.
Yeah.
But then it is your duty to accept their interpretation. Have you accepted it?
This particular point I pointed out that they, what is not in the fact. Of course, don't you take.
So that is what. So if it has been pointed out today and that was not the issue there, why should I take his interpretation?
Specific para India.
That was.
That malad, if the private respondent, they pointed at the fraud malad, the document of.
No, that's all right. That is all right. It can be pointed out by XYZ. But it has to be accepted by someone. No?
Then of course will be a separate.
Accepted by you,
Yes.
not by. Huh?
Examining the merits of the decision-making authority at that point
Malad,
of time.
let me complete my part. Then I suppose you.
He's coming in between.
Yes.
How much money is involved?
He is getting 60 lakhs more than me. My quote is 1 crore 50 lakhs, this is 2 crores 12 lakhs. So he's getting 60 lakhs more than the rate I have given. For the same quality of product, which has otherwise been accepted on the quality point. So that 60 lakhs.
That part.
Really? I can always tell my amount. I know my amount. I can tell my amount.
The lottery is the malad, the cloud of.
My amount of.
But yeah, but that won't be fair right now. You're trying to influence the court.
Not trying
With-
to
with-
influence,
Yes,
but.
without that aspect of the matter being out in the open as on day.
Because I know my rate. As-
No, but
as-
then no one's asking for it.
I understand. But then as a point to indicate as to.
I
why
can
my
understand
decision-
if the financial bids were open. But when it's not been open, then
Then malad, I brought it up when I placed one. Specifically, what the that cannot be done. Technically not viable.
correct. If technically it's not viable, there's no
It
point.
cannot be considered, obviously, it's not been open.
Anyway, what is that? Anyways, yes.
Now, the second round.
Okay, so first round goes to him.
Going by the details, malad, each malad vote, he has submitted vote, but only one is.
Correct.
Or we have,
It's not the question, yes. So
we have.
the issue is not whether the issue is whether he has submitted the documents or not.
Both to
Both I have heard.
No, so you see out here, it says a bidder did not submit. So it's not the issue of, it's not with regard to the merits of that document. It's the issue is whether the document has been submitted or not. And it has been submitted.
Submitted.
So that is the issue.
But the difficulty is, malad, so far as
You are minus.
no evidence in your
Yeah.
transfer.
For the time being, you are minus. He's zero, your minus is one.
So what has happened is property certificate is concerned, well, that the petitioner has submitted, it has been addressed to some another authority. I accept that. So that's why this ground was taken. But my lord, if you go by the provision, it says balance sheet also is enough. So balance sheet is there, that's why I'm saying that.
That's
And
what,
then
so he,
look at my
so he has
concern.
submitted the
Otherwise,
document.
I, both years submitted, if you reject one, the other remain.
Correct.
Because all helpful. That's the well, fair submission.
Okay,
We can point out some technical point of one there, of course.
The rejection was, I did not.
okay,
submit.
number two.
The bidder did not submit details of field and trained service engineer based in Assam.
Yes.
What
Let us
do we
see
find
the
this point
The record.
at page 196.
One nine six. Yes.
Clause number 12. It says, service and support arrangement. Bidders should have skilled and trained service engineers based at Assam or field and market. Now, my lord, this particular clause will have to be there. Which, my lord? There's another clause. Yes, page 192, clause number 22 and 23.
One ninety-two clause.
Clause 22 and 23. I'll explain in a minute why it have to be there. Says, my lord, dedicated 22 says, the dedicated press toll-free phone numbers of service support. Bidder OEM must have dedicated toll-free phone numbers of service support. 23 says, escalation metrics for service support. Bidder OEM must provide escalation metrics of telephone numbers of service support. Here, my lord, they submitted my lord, details of areas employees and their phone number. None of those employees are from the federal. The present petition. This particular, at least one, my lord, technical person will have to be from the federal. There I will demonstrate from their own business. Or actually.
They will also have to show that a document is required to be submitted. along
You
with the-
get your time, you get your.
Just to clarify.
Others are sub-
This is the submission of who? The petitioner.
Details of escalation metric of telephone numbers of service support.
Yes.
All are from outside the state also. That's why, my lord, now when we raise the issue, they have submitted a certain document, my lord, that pays, my lord, people to. That is dated 24 to 2025, wherein, my lord, they have named a particular engineer or a service provider who hails from the state also. Giving it proper address and phone number. That was, my lord, is the time when they submitted their appeal or their representation, even after the clarification part of the document, from 11.
Now, this, okay, this is service support.
None of them are from the state also. That has been submitted by the private respondent number 5.
So this is a petitioner's document.
Yes, now the
That is
so well, how others have submitted, the respondent 5 has submitted the document. Wherein they have named and given the address, phone number, everything of an employee of the state, that they have a center here and this. So we want it, my lord, dedicated staff here. They are, my lord, all from outside the state, only
How to remove that from outside the state?
because, my lord, when we raise the issue, based on, as a clarification.
They got-
Giving the address and all. They can show that yes, from the charges going through it from the state of Assam. That ground goes. Now, Lord, seriously, third.
No, before that, so let him reply to second.
Yes.
So now the second one, he says that the list of the support staff that they have given, now this list.
Yes.
None of them belong to the state of.
Now, first, let me first clarify. There is one part for. Part was in Sorba, serial number 8.
Yes.
He is from Assam. Now, first, let me just clarify one aspect.
Yes.
Now, if a lawsuit will come to page 196 with the cost of repetition, I'd just like to show
Yes.
that clause 12.
Yes.
What does clause 12 actually says? 196. Bidders should have skilled and trained service engineers based at Assam. It does not indicate that the document to that regard has to be provided. Lawsuit always in a tender document, there will be documents which are supposed to be provided at the time of the bid. This particular document was not recorded. It only says bidders should have, bidders should submit. It doesn't say so. No, logical, because otherwise, how would the tenderer know as to what is to be submitted? Is this document required to be submitted?
Supposing I say that, that the bidder should have skilled and trained service engineers
Then I have.
based in USA, then
No,
you'll just give a list of names without showing their address.
No, whether it
How
will
will
be,
I know that they're based in USA?
first of all, how will the tenderer know that I need to submit that document? This is not a clause for submission of document. That's what I'm saying. This is not a clause for submission of documents. Clause number 12.
No, you come to page 195.
Yes, Lordship.
It says 5 document.
No, this
The-
is 5. Then Lordship,
The following original documents are required.
till 7, Roman 7, Lordship, till Roman 7.
7.
Yes.
No,
Now this is not-
no, it requires everything.
No, Lordship. 5 is document. Numerical 5 is document
Then
which has,
read below that.
yes,
It says the following original documents are required. Number 1, invoice.
yes.
Number
all
2,
Roman.
case-wise packing list.
Yes,
3,
till 7.
4, 5, 6,
6,
7.
7. And that's
8.
No, not
Hard
8.
copy should be handed over, accredited, so.
This is 6, Lordship. No, numerical 6. Lordship, kindly see. Yes, Lordship. Page 195, clause for document is numerical 5 has got 7 documents required, which is in Roman, it ends at Roman 7.
I don't think.
No,
Oh,
page-
yeah.
Page
7, yes.
96 documents.
Yes.
This is different. This is not a part of the serial number 5. The
No,
document,
it says 5. Okay,
yes,
six.
this is 6. EMD should be handed over. This is different.
Okay, now, the bidder should have skilled and trained service engineers based at Assam. This can be only be proved by way of a document, nothing else.
Everyone engagement letter.
Yes, it has to be a document. Everyone. All these
Doctor,
6, 7,
sir,
8, they're all
sir,
documents.
The document clause is serial number 5 only, numerical 5.
That is your.
No, that will be the understanding of any tenderer if he looks into this condition. But you will just hear it. Let me just.
No, you see, the thing is that I'm shaking my head this way is because I want to understand also, you see. Otherwise, if I say, no, this means yes, then you are going to get confused.
So
So I am nodding my head because I want that aspect to be clarified. You see, if I said that, yes, if I said, carry on saying this, you're never going to clarify the issue. So please clarify.
I will just take another minute of your lordship's time to indicate what is been presented here or what is been required here. Serial number 5, numerical serial number 5 talks about documents.
Correct?
And they have got Roman 1 to Roman 7
Correct?
are the documents.
Yes.
Now, therefore, point 5 ends here.
No, you see,
Numerical point 5 ends here.
you see, clause 5 talks of original document. Okay, clause 5 talks of original document. 6, 7, 8, 9, 10, 11, 12 might not require original document.
So then let us go to serial number 1 then, your lordship, as to what is the heading above serial number 1. The serial number 5, before that, there are serial number 4, 3, 2, and 1. And what is the heading? Page 194. And regarding that particular aspect,
So
Yes,
what does it require?
yes, Lordship will see.
Yes.
What is this? What is basically this? It says page 194, top portion. Buyer added bid specific ATC. Buyer added text-based ATC. JICA funded procurement. Supplier will provide insurance cover, number one. Number two, payment terms and conditions. So these are all different aspects of the NIT.
Come to 196, number 6 says EMD hard copy should be handed over.
Yes,
Number 7, accredited bidder, OME should have local office
yes,
with valid trade license.
yes,
So you need document again out there.
yes. But
Then
for
manufacturing authorized certificate.
what has been required?
For
is
bidders
provide-
outside India, OME affiliated certificate. Accredited bidder must have a 2-year experience in works of civil and.
Yes, but for 12, what is the language? Bidder should have skill. Bidder should submit a list of the skill. It doesn't say that way. It says you should have a list. You should have skilled and trained employees. It doesn't say give the proof of the same also by submitting that required document. So plain understanding of reading this particular clause would indicate that I must have the capacity of skilled and trained service engineers based in setup at my disposal. But it does not indicate that I should provide the same document also, because the language does not speak in that regard. It's my submission. And
That is their interpretation.
that is my interpretation, reading the language in the clause 12 clause, because it says should have. Should have submitted does not say that.
Okay.
Now, Lordship, regarding that, page 192. But then this clause is otherwise met in page 192, clause 22 and 23. Clause 22, page 192, clause 22 and 23. Service support. Service and support, what is not that?
Yeah.
Yes. Now, the argument that has come from another friend is that I am supposed to give a detailed list of the persons who are going to provide service and support under this. And I also agree to that. Yes, in this clause, I have to submit, and I have submitted. And where is that list? Yeah. That is what before your lordships. This particular list. Now, in that list, the argument is that no one from here is from Assam. Now, lordship had asked them how did they verify. I forgot the answer. They said it is not there. But then
No, the answer is because of your clarification made with regard to the letter sent after the opening of the bid, where you have mentioned one name.
Yes.
That's
So in this document, I see, serial number 8, Parthajyoti Sarma. Lots of people kindly note this name. Serial number 8, Parthajit Sarma. He happens to be based in Assam. So therefore, this argument also,
But why didn't you clarify that in page 222?
222. I'll just. Okay. 222, what is it? No, what is it? Other two. This is the name which has been given additional also. In the list that has been already provided. And another aspect also.
Just a minute.
Yes.
Let's not go so far. Page 222.
I am at page 222.
Yes,
The engineer's name is Mr. Jadav Tumum.
correct.
Yes.
There's not additional. There's no additional there. Where is that word coming from?
So that list,
No. I mean, in this page 222. There is, you have said subject details so of service engineers based at Assam.
yes.
We hereby confirm that we do have skilled and trained service engineer based at Assam to meet up with so the details are given below. Engineer 1.
Therefore, I can clarify this on two aspects. Number one, we had provided the list otherwise of the company's service and support in that particular bunch of papers where I showed the name Parthajit Sharma number 1. Now, this particular.
Where?
No, this No, this one.
There's nothing here to clarify. You see, if Parthos was based in Assam, why is his name not here at page 222?
He is from the company. The
He's from
company
which
from where-
company?
Because we are not the OEM. We are the supplier of a OEM product, which is this particular cardiac monitor. The company's officer is Parthojit Sharma. That is what has been indicated here. First, you will see that. Medsel, that the company's name is Medsel, the OEM, original OEM. At the top, Medsel. And Gossip will see at serial number 8 that Parthojit Sharma is the name. Because at phase 192, they do not say it has to be based on SR.
Who was to supply the equipment that machine you?
Yes, as a
True.
supplier.
You're the supplier.
And when the clarification,
And the supplier is to have the engine. And the supplier is to have the engine. Not not the manufacturer. Manufacturer might have
yes.
but you are supposed to have the engine.
Now, my explanation of reading clause 12 again does not say you have to submit. In fact, in the clarification also, they did not ask for
No,
this.
no, they don't forget that submit or should have or something. The fact is that you are the person who answered the tender.
When it was asked.
You are the one who gave the bid. You are the one who's supposed to have the engineer based in Assam,
And I have.
not the manufacturer of the machine.
If gossip sees clause 12, yes, the bidder has to have.
The bidder has to have. So you do not have,
No, I have. That is what I have sold to them.
but the Partha is not your employee.
No. Part.
Partha is not your employee.
That
Partha is
is,
not the bidder's employee.
that is in terms of the clause 22 at page 192. Clause 22, where they say they need service and support. So in that aspect, we have given part of the Sarma's name. Now regarding the clause 12, where they say the bidder should also have an engineer. My understanding,
Bidder has to have an engineer. What do you mean?
I understand.
Should
So,
also
and
have.
therefore,
The bidder is the one who has to have.
yes, and therefore, when they asked, do you have it? I gave it to them because clause 12 does not say that I should provide the document for that regard. The bidder should have.
Okay, so your next, your submission is, even if the bidder did not have an engineer, did not submit
Yeah.
the document regarding him having an engineer in Assam. The fact that the clause did not require, the clause did not require
Plain reading of the
the
clause. does not
petitioner
indicate-
to submit the name of the
I will
engineer,
comment to that regard.
document to that regard.
So therefore,
The fact that he had it was enough.
So therefore, he had it was enough, and when the clarification was sought, it was given. But then another aspect, on 11/2, when the first clarification was sought, this was not a point there. Before the tender evaluation took place, they had asked for clarification on 9 particular points. Therein, this particular issue was not here. There's philosophy.
How does that help you?
It helped me because when they initially evaluated the tender paper to seek clarification, this was not a point to which they had find fault with. So therefore, 29, I just wrote the date, 29/1 was when the initial bid was submitted for the first time, 29/1, 2025.
29/1/25.
2025, when the bid was submitted. On 11/2/2025, an email was given or circulated to various bidders asking for clarificatory documents. The word is documents there. Asking for clarificatory documents. I will just show that directly to your lordship. Your lordship will kindly come to page 199, just for a clarification on that. Because it is not a part of that clarificatory record. Page 199.
Yes,
This is dated 11/2/2025. Lordship will just see the language. You are requested to provide the supporting document clarifying the below mentioned points. So now they asked me on 9 particular counts document, but this issue was not here. So therefore, at that point of time, when clarifications were showed on these, my bid papers, this was not a ground that was found fault with. This was a subsequent ground taken by them.
So how does it matter? Does it mean that just because they did not ask for clarification, that it became the entire selection process?
No, I'm on a different aspect. It matters because clause 12 does not indicate that I need to submit that document to that effect. So therefore, I'm not required to submit a document to that effect, and therefore in the clarification, they did not find fault with non-submission of that document. Because clause 12 clearly says bidders should have. For others, they say documents have to be provided. The word used is submitted, provided. As a tenderer, I will go by the language in the NIT terms and conditions. The NIT terms and conditions.
See, it's very simple. You've done many tenders. Now, when they say tender should have 20 bulldozers,
They will
what way should have 20 bulldozers? What do they want? They want to know that you have 20 bulldozers.
They
Now, are you going to say, since you have not used the word submit, I don't need to show them that I actually have 20 bulldozers?
Lordship knows much more than me.
No, I'm just asking you.
In those construction NITs, they will have specific instructions for bidders where they will say documents will be provided to that effect.
No,
The registration certificate, the insurance certificate,
I'm just asking you.
yes, it will be there. Those clauses will
Why
be
not?
inbuilt.
No, why not?
Key equipment and key personnel clause is referring to. There will be an appendix to the ITB, and they will have that particular list of equipment. I was, in fact, day before yesterday, I was doing a matter on that aspect, construction matter, road construction. They have key personnel and key equipment. The list will be there as an appendix to the ITB. And the instruction to bidders ITB will have a clause that will indicate that these equipment will be required. And how do you prove it? By submitting the registration certificate and up-to-date insurance certificate of those equipment. So those will be there.
Now, you see,
Inscribed in
now,
the
now
NIT
let us see,
conditions.
now let us see this contract. The tender is for a cardio machine.
Cardio supply, cardio.
Now, a cardio machine, once it is supplied, what is it? It's going to be used. Service is the main thing.
Therefore, the service engineer has to be there in a sub. I understand. And therefore, they say you should have one. Now, when they say, do you have it? Actually, as if like they're asking me the proof for that. In my clarification, yes, it's a proof that yes, I do have it. So therefore, it cannot be a measure ground to non-suit me in the NIT process. The very fact because clause 12 indicates that it does not refer to submission of documents in any sense altogether. It says you should have. The other clause will see. They say EMD hard copy has to be submitted. How do I infer that? How do I infer
Okay,
that?
I think we're going around the bush now, I think.
No.
I
So
think
my submission is,
your submission is that since you are not asked for a clarification,
first of all,
and that as it was not a requirement under the clause to submit any document with regard to the said issue, there was no requirement for me to really clarify anything.
that's the clause. I was, the tenderer thought this document is not required to be submitted because clause 12 does not indicate submission of the document. But when the clarification was sought, we presented them with the clarification that
That's what I'm saying. Prior to clarification is not required to be clarified.
not to be submitted. I'm not saying not to be clarified, just not to be submitted.
So counter to what I understand is page 194 of the 194. Clause number 4, down below, warranty and maintenance. Clause number 4. Yes, warranty and maintenance, it says supplier agrees to provide. Yet no additional charge, a comprehensive on-site warranty at the hospital site, including but not limited to material and labor for it. Labor for it, all components. The warranty shall be valid for a period of 12 months from the date of installation. Supplier warrants that the items and influence of. So these are one of various conditions that have been laid out, but nowhere not a single requirement been made that a document will have to be submitted or undertaking will have to be submitted. Despite that, madam, petitioner knows that he will have to submit one undertaking. The document has been submitted, also in the third page of the bunch that I have submitted. Technical bit of the petition. Applying this particular clause. Because from 4 to my lord, clause 30, all my documents will have to be submitted, what should be the first one? They are submitted, without their being, any document being sought for, page, third page, the fourth page of the plan.
1, 2, 3, 4. Yes.
This, at the top, my lord, undertaking on warranty and maintenance.
No, management sports service.
No, my lord,
Progressive enterprise.
yes, progress, page number 4.
1, 2, 3, 4.
No, there is a page number, my lord, the fourth page. available.
You see, one is then first, then
First is
second,
profile of the bidder.
half profile of the bidder. Number two,
Next is the, my lord,
self-declaration.
next is manufacturer authorization form.
Third is an undertaking.
On warranty.
Yes, yes.
These has been submitted, my lord, whereas, my lord, not a single indication that they will have to submit this particular. They know it will have to be submitted. And same way, my lord, manufacturer's authorization, that clause, Lord, you will see. That page, 8. 196, clause number 8, Lord, you will see, same, my lord, part. Clause 8, manufacturer authorization certificate should be, with specification should be on OEM letterhead so and so.
So that has to be on, that ahead.
No, even then,
Has to be submitted.
it has been submitted, so that's why I'm saying. that.
No, it shows me that it should be submitted. And should be on OEM letterhead.
Yes. Then, my lord, 7 says accredited bidder OEM for the all local office in the state of Assam for the last 2 years with valid trade license or necessary arrangement, fulfilling above requirements to be supported valid document and everything. So now, my lord, so far as 4 is concerned, he has submitted. Otherwise, my lord, how many bidders participate in? He is qualified, 6 plus 3.
So others have all submitted.
Yes, they have submitted. So it's quite-
Because are not that we get not like that. Yeah, because those big papers are not before one. Fine.
so those are not on the Chennai document.
Anyway, we'll see, the next, let's go to 3.
Yes, page 207.
Am I out and two? Am I 0 and 2?
Yeah, yeah, right. Yeah,
Draw.
might, yes.
He said
Point
that-
going to towards him.
207, my lord.
So,
The OEM did not submit past experience document. Yes, sir.
207.
No, not 207, sir. 199.
No, 207.
Yes, that ground. Ground.
207.
Did not submit past
Did not submit past experience document.
Here, my lord, the ground that we have stated in our affidavit. Past experience certificate not there. Though he has submitted, we could not verify.
That's a different thing. Well, you see, if you submitted, the issue of you not verifying is your problem.
So, definitely, my lord, documents will come.
No, you see, the thing is that I can understand if it was not verified. But if you could have verified, and then if you have tried to verify it and found that it was not verifiable, then that's a different thing.
So what is, why I'm saying this, my lord, I, but the fact remains that, my lord, in the clarification that we have fought for, that they submitted the same document. Here, there should have
Now,
been.
let us see, they did not submit past experience document. Now, let us see this past experience document.
Otherwise, my lord, they have submitted some document.
They have
Yes,
submitted.
yes, yes.
Now, so what is wrong? If they have submitted, they have submitted.
So, my lord, we have to verify that. Now,
Whether, so have you verified? Have you tried to verify?
So this, my lord, because they have submitted a work order, they have submitted a invoice with their signature. Nothing is there, no certificate, no some certificate that it has been installed by. the-
Okay, let us see the document.
Yes. Lord, we will find that, my lord. Well, of the legible copy, Lord, we will find in this part. My lord will have a look at it. Find the legible, my lord, will find it again. Legend 1,
Yes,
this is the jam portal, my lord. The supply order is for 7. contract, at the top it says contract. It is by the 24th January 2023. It says the number of quantity 7. Paying authority detail says railway. Well, that type of inspection or type of inspection. This inspection agency, financial approval detail, then my lord, paying authority. Paying authority, it is the railway. So it is the railway who has for it. Is the contract. And in the next page, what you will see, there is a tax invoice. It has been signed by the petitioner. Nothing is there to show that the railways have. It has been supplied or installed at the railway has called for. And my lord,
Where's that signed by
the next page. The next tax invoice.
tax invoice?
47 items. They have indicated is their signature on it. Nothing to show that it was actually.
Done by
Some
them.
from the authority that satisfactorily 7 items have been done. Same way in the next page, contract 18th of July 2022, two items.
Item 2.
Yes, 2 items, next page, tax invoice. It is the petitioner's own document, tax invoice. Nothing to show that it has or some self-certification or from the authorities that they have been satisfactorily installed. Same way, whatever document has been submitted.
It's a self-signed,
Yes.
self-signed
Part of the
document.
Nothing has,
Huh?
when in the clarification, when it's offered on 11th, nothing has been raised to us to show that yes, we have installed.
So the authority who had required the supplies to be made has not given any.
Nothing has, not even a certificate. Up to see the
No completion certificate or
document. Then what is the specification? Nothing has been indicated. Because what you could say and tax involved. So, this is one aspect, madam.
there is another aspect to 3.
Yes, madam. The next round, my lord.
No, before next round, yes to
No,
answer.
yeah, he will decide.
Yes. Yes. Mr. PP that was looking at me intently. We'll give you a chance after him.
Now, one aspect is very clear that the ground on which I was rejected in the bid evaluation says documents not been submitted. But the argument today is that documents are submitted, but then page 206 document.
7.
Page 206 of the of the affidavit. What do they say? Bidders OEM did not submit past experience documents. So non-submission of a document and submitting the document to which now they say they were not able to verify, supposedly there's a different argument altogether and a different stand altogether. Non-submission would mean there is no documents on the form.
Let us see this clause. Where is clause
Yes.
3?
Therefore, I'll show you Lordship the clause. Lordship will kindly come to past experience.
So we'll find in the affidavit itself, page 184.
Page 184, serial number 4 at the bottom.
2 and 4, 2, 4. One more clause. in there.
Past performance.
2 and 4.
Yes.
And another clause that pays 192, clause number 30. Clause number 30 at page 192.
Page
92,
192.
clause number 30, which deals with past project experience. That is the experience. So these 3 clauses has to be seen as to what document was required under that clause. And it says the contract paper along with self-attested invoice clause.
192.
192.
192,
L,
cost 30,
clause 13, right at the bottom.
30, 30.
30, yes, Your Lordship, 30. Proof of past experience and project experience clause. For fulfilling the experience criteria, any one of the following documents will be considered as a valid proof for meeting the experience criteria. What is it? Contract copy along with invoice with self-certification by the bidder. That service supplies against that invoice has been executed.
So was,
Any one of the following.
was
any-
contract copy given?
Yes, contract copy given, and along with that, the invoice, which is self-certified, is given. So what else should I give now beyond this? And how do they therefore submit that I have not submitted the document? So first of all, they admit document is submitted. Now they find fault with the document by saying that this is not the up-to-date document. But in fact, in their clause itself, they say, this is what is required. I have given this.
So not any document, just because there was there, you clear on invoice and give it back without any.
Contract copy along with invoice.
Yes.
With invoice, with self-certification.
Something in the invoice to show that it has been received by the authority.
Do they say so? Self-certification?
Invoice issued by whom?
Here it is the petitioner who is citing authorizing.
No, invoice is basically a receipt.
And lordship is the tax invoice, not the invoice.
The basic, stick with me for assistance.
Listen,
Lordship will see that that previous plus one form. Yes. Yes. One it says contract. It is for supply of 7 items.
okay, look, what I do is we take it up at 2. Okay, I have got one matter, because we will not finish in another 5 minutes. We are only at serial number 3, 4, 5, 6 is still there. So I will finish that Mr. R.R. Gogoi's matter with that.
Only one thing is that,
Ah.
I do. But after my representation, they rejected me only on one count.
We'll see now.
And therefore it now seems the documents that they say were not produced. Everything is now coming out because it has been produced, but they are finding fault on the merits of the document.
I don't know, we'll see. You know,
So it seems this has already been taken care of when I filed my representation. And then they saw that everything is taken care of. The only ground remaining is that certificate of CA on which they rejected me. That is what is communicated to me.
I don't know, because that serial number 2 is here.
That cannot be a.
I don't know, I don't know. I don't know. Let us see.
Is it mandatory, directory, that those arguments will come? Is it
No,
mandatory,
that is,
directory?
you see, you know the Supreme Court judgment, how it is. You have to see that context, not through the lens of what the Supreme Court has
When
held.
there comes in conflict, we follow scrupulously is what Justice Council has said. I had followed the instructions scrupulously. It says, we must have, I have it. You must submit, I will submit. Then I'll submit. They do not ask for that.
You see.
But I have not brought the judgment together.
No, it doesn't matter. You can bring it some other day also, but facts, let us be clear.
Yes. I'm obliged, sir.
Yes, yes, yes.
My item, I take for 8.
Yes.
So it takes time, right? Okay. Take that tomorrow, day after.
Difficult. It will be difficult. It's all fact. After vacation. After vacation. Right, on item 8, on the prayer of the council for the respondent number for the petitioner. This is the matter of the petition.
Another dependent is the way out of this. Perhaps. And I think permitted by an additional activity incorporating the certificate in the particular purpose, the sub-register or the registrar, like it as far. So in that there is no such society as a high system. In that Sankura in these things, I'd attach that certificate. That is the requirement on, not on the distance part. That is a registered trust or a recognized management firm. I will enclose a certificate from the authority imposing the list of trusts and societies in that area.
You'll have to make them a party also.
I will make them a party also. I will that dilute that on because of.
No, you see, only one thing. to be a public place of worship, that explanation, the conditions provided in the explanation will have to be complied with. Now, whether it complies with that explanation, the terms and conditions of the explanation, is something we will have to see. So that is again a issue that is again a question of fact, which will have to be proved. So I think the best is you withdraw this and fight afresh straight away. Because this has to be also challenged, put to challenge.
And withdraw with the request to file a press. release.
I think that's,
Offering-
otherwise by the time you file your everything, this is going to be a mess.
Like the states man recognized management committee. To the president and a secretary of that one of the to one of these changes, then permanent of the change that the voted area.
No, only thing is that public place of worship, whether it comes within that explanation under 289.
Wait.
That's all. That is the only thing that has to be seen. So that, I do not know whether writ also will be the best. But you can try your luck for the time. But if the more questions of fact arise, then you'll have to go to civil.
Yes.
But for now, we'll give you the permission. Mr.
And good.
N. Barwana, counsel for the petition. Heard Mr. N. Barwana, counsel for the petition, and Mr. R. Goyal, counsel for the excise department. Is there Mr. Sarda? Mr. R. Tarugdar appears for the court. The petitioner is aggrieved with the rejection of his bid in response to NIT for operating an IMFL offshore in PSK 3, Tunpura. The petitioner counsel submit that the bid of the petitioner was rejected on the ground that it is in proximity to Hari Kirtan Mandali. Which according to the petitioner is not a public place of worship as given in the explanation to Rule 289
289.
of the Assam Excise Rule 2015. Mr. Arat Goyal, counsel for the petitioner, has submitted parawise comments issued to him by letter number PX full stop 9 slash 2025 slash 82 dated 31/5/25 issued by the Superintendent of Excise, Tinsukia. The counsel for the Excise Department submits that in terms of the above letter dated 31/5/2025 and the connected document therein, the site where the petitioner's off-shop was proposed to be established was at a distance of 106 meters from Namgarh, C number Natun Balijan, Tunpura. As the distance between the petitioner's proposed IMFL offshore and the public place of worship was within the prohibited 150 meters, the petitioner application was correctly rejected. Next para. The counsel for the petitioner, submits that as the letter dated, as the parawise comment, as the contents of the parawise comments dated 31/5/2025 issued by the superintendent of excise would have to be put to challenge, and as the petitioner requires to include some more parties, he would like to withdraw the writ petition with liberty to file. The next paragraph. The letter dated 31/5/2025 issued by the superintendent of excise is made, and the documents in its therein are made a part of the report and marked as an X collectively. The petitioner's counsel's prayer is allowed. The writ petition is dismissed as infectious, dismissed as withdrawn, with liberty to file a file. Instead, today is 17/6. You can take a photo of this. That goes automatically. I will not say it. Take a photo. Let him take a photo of it.
I'll answer. to Bala.
Okay, you serve no copy.
Okay.
That's all. That we'll have to see whether it comes within that public place of work.
The explanation part says that whether it is given by committee and the explanation says recognized committee. Has to, the public paper also has to give us by recognized committee, and it is given by the committee. Now the NOC doesn't say about registration. Yes, I don't have registration, but we are a committee. Now this the public place of worship will amount to work with from
No, but then we have also got to see, as per the explanation, the built-up area appears to be 200 feet.
Yeah.
Whether it's 200 feet, I doubt. 200 feet is quite huge. Nothing has been mentioned by the petition. Paka structure, 200 feet. So if it does not come within that, then I think your verification that has been done will have to go. No, then if it does not become a public
Yes,
thing, then there's no question of distance. Distance does not survive.
I have a prayer. Just now I have been informed that there are 12 matters listed in Arunachal Itanagar Court tomorrow. Oil India matters regarding crude oil exploration. As I'm standing up for Oil India, I have to be present. So I have also asked him if we can have it on 19th further proceedings. Because I'll have to.
May I complete my?
Or for like 1 hour, I can see you. But I have to go home and then.
You do it fast. Yes. Only thing is that now we have finished the third, now the fourth one. What is the fourth one? Yes, fourth clause.
Either did not submit EU certificate.
Page, where's the clause?
207, my lord.
No, clause in the tender notice. Okay, right, on the prayer, the petitioner. Petitioner. Okay, on the prayer made by the council for the parties, this is the matter of the petition.
So page 187.
Page 187. The fourth point.
Yes. No, down below, my lord, additional specification parameters. Cardiac monitor with Jeffrey.
187.
Yes, 187. Certification required.
187. 187.
Down below, my lord.
Yes,
To start, certification required. US FDA or UCE, European certificate,
certification required, yes.
4 digit 45.
Here, where the ground is the space 207, serial number 4, either did not submit EU certificate. What should have been that that submitted the document is expired.
Page 207 says, bidder did not submit use certificate. Use certificate. Okay. So he did not submit it.
So submitted, ground it is expired, but I have also submitted the extension document along with them.
Okay. According to them, it is expired.
Expired, but the extension certificate is just behind that.
Page,
No, it's a part of the bid document. Yeah. Bid document.
Yes, document minutes are just 1.0. It's not 5 flashbacks.
starting with the progressive.
So, what are other one? First one. First people. This one. Here I have flashback.
You give that back. Return? EU, yes, EU, yes.
What you will see, my lord, in the right hand side, down below, corner. Expiring date 27/5.
So, yes,
Now, my lord, according to the verifying committee,
what is the last date?
29/1, 24, 25.
29/1.
Okay, so that is expired.
That is
You
expired.
will see the second document thereafter.
The
Is the,
next page.
yes, issued by the same authority, MTIC, notified body confirmation letter to the OEM, Mastros Electronic Communications. So herein, we also will see the next page. Once it is expired, we have to apply before that. After application for issuance of the certificate, there is a transitional time wherein they keep it valid. So it has been stated herein. Plus you will see the second page
Yes.
of that letter.
Yes.
The transition timeline that apply to the devices covered by this letter, subject to the manufacturer's continued compliance of the other conditions in User Article 2 and so are shown below. 1, 2, 3, the third point, the bullet third point, 31st December 2028 for other class 2B devices. Now, this is a class 2 device that will also be find from the next page. Next page, model Vital Wave class 2B, which is the model that has been provided. So now they therefore do not,
Wait. What is table 2, table 1,
first table,
first table,
classified in model Vital Wave,
vital rate is
and then just next to that, class 2B.
past 2 PS.
Yes. So for this particular model, the transitional timeline for which this compliance, this extension is there, is till 31st December 2028. That
Yes.
bullet point number 3.
Yes.
So this has also been provided along with it. European certificate, it might have expired, but we also apply for extension. So during that time, till the certificate actually comes, they give us letters of this, that this will continue for a transitional time, because they have to also fit in that between the.
So have the,
This is not been appreciated.
have
It is-
the certificate been, renewed?
It has been renewed. So, not the document number, it was renewed now. They have received the renewal also now.
Huh?
Then it is a failure of the technical evaluation committee that they are not an expert that way. If they cannot,
I don't know, is it?
Going by the.
I do not know. What do you mean the device is covered by this? The thing that they are going to supply is a 2B device or? How do you say, how do you say that this transition timeline will apply to 2B devices?
because
Do you mean to say that the cardio machine that they are going to supply is a 2B device?
yes, Vital Wave is the machine.
I don't know. Where is
Yes, lots of people see that page, model, Vital Wave. So the cardiac monitor machine that was provided.
It's a debris, it's a file. Model vital, I don't know. Yes.
That is the model given.
Oh, you'll have to obtain instructions.
Yes, that's what, my lord, of course.
Slightly above our.
Check my lord.
I can't say Baba pay grade, but it's slightly too technical for us.
Therefore, I was saying if, because our case, what is now, with also been now available from the records is that first they say documents not been submitted. Document
No, 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 forget that. No. Okay, this is that. Now then we'll go to the fifth item.
Yeah.
Fifth. We're going to waste time. Next, fifth.
So I say the documents are there.
Documents are there.
Then I say-
According to you, documents are there. The translational phase takes care of their expiry.
Yes.
Yes.
Now, next question, the bidder did not publish financial statement certificate.
Bidder did not submit financial standard certificate. Yes.
This follows the clause.
Clause.
Page 189.
189.
B, generic B. Bidder financial statement. The bidder should not be after liquidation, post, receivership or similar proceedings should not be bankrupt. Bidder to upload undertaking to be effect with the thing.
Ah. So did not submit.
Bidder did not say financial standing certificate was not done. Undertaking was, yes.
Did not submit financial standing certificate.
Where did it take words from the NIC? Where the certificate take words? They are asking for an undertaking only. Let them show that particular clause. They are asking for undertaking. I gave my undertaking. Now they are saying certificate from where they are saying. Let them show that particular clause of the NIC. This all everything is the center even public has not done their work in a proper sense. Maybe to accommodate the private response.
Page 211 of the clarification that
211.
yes. Right, page 211.
Yes.
It's a tender term.
Bidder number 5 minutes, let's start. Bidder's financial statement can close. Please.
Clause
Correct.
3, they are
So financial standing is enough to show that they are not bankrupt or under liquidation.
clause
That
is
clause
an-
you will find at page 234.
234.
Yes.
Yes.
Which is the document for us. No, not the undertaking. This document was furnished, madam. Along with this clarification of 24 of the bank.
So page 234 submitted.
Yes.
Along with what?
Along with the clarification, madam.
Where is the clarification?
211, 211. Not the clarification by representation.
No, along with the bid, it did not submit.
I submitted the undertaking as recorded as the clause.
Where is that thing? Sarah, in your writ petition?
So this petition, that entire, this document I have got.
In the bid, so he submitted the undertaking.
But that, from the bank, nothing was.
But it's not required. It's not required.
Bidder to upload undertaking to this effect. Bidder to upload undertaking to this effect. So the bidder has given the undertaking to the effect.
Undertaking, give it.
Give it.
Okay,
How
then
is
next,
it not there?
next. Page,
Yes, page
Last-
207, last one. Bidder did not submit declaration of spare parts available. That my lord, I have checked my lord in the tender document. Some document has been submitted. I must be there.
okay, so page, that is page, what is the clause? In which page?
Yes. Page, 188, page 188 of the.
188.
Yes.
Clause number 8.
Clause 8.
Clause 8 is 108.
Seller shall provide.
Clause clause 8. Clause 8, no?
Clause 8 is 108.
Yes.
But, lottery will be the one that I have given my, technical bit. Just,
document prior to that, my lord, escalation metrics. But, yes, it's tagged, it's marked, yes. Escalation. Yeah. That's prior to that. Prior to that, yes. Yeah, list of spare parts accessories for given. They've given a list, but the post page, seller will provide material, information, etc. pertaining to spare parts. Only a list has been given. So what do you mean by can provide material? Materials which you might told us, so that these are the materials that are available, not in a chart just something that they are, these are the parts that are available. Like a booklet or something like that.
You're not asking for samples here. And
But
there will be
about
a cost for
there are
sample only.
catalogs and all, nothing has been given.
They're all interfaced now. What is not a before? Catalog is there. The catalog is also
Of
there.
spare parts. Let them show whether they connect something. Because it says, sellers will provide materials and information.
The ground of rejection is bidder did not submit declaration on spare part. And the declaration is there.
We go by the tender conditions.
No, we go by the rejection count. The rejection count is bidder did not submit declaration on spare part availability. As in the bindings of the technical evaluation part. Declaration. The declaration is here for spare part, as well as the list is there.
It's into the cloud. Otherwise, it says, it provide materials and information. Okay, Mr. PT Data, what do you want to say? Or what, the best thing is, I think we will fix another date for you to make a
On
submission.
19th.
है ना? So that all your ammunition will not be, I think it will go to waste, will get prepared for the next week. Actually, what I want to do is I want to record your submissions. Otherwise, if I don't record it now, I have to hear you all afraid. And he's in a hurry to go to, he's arguing here in court number 4, but he says that he's got more important matters to argue in Arunachal Pradesh.
Not important.
So we have got to, this year gives more important to Arunachal Pradesh. Who are we to say no, you cannot?
I've never said that. Therefore, I said I'll be here.
Because he's giving this court only 1 more hour's time to hear his
I'm
side
here
of the
process
story.
disposal till 5 p.m. After that, I'll go.
Okay, right. Heard Mr. A. Sharma, learned counsel for the petitioner. And Mr. P. And Mr. P. Will learn additional or what? Huh? Standing counsel, health department. As well as Mr. P. P. Data, learned counsel for the point number 2. The petitioner's counsel. This way. The issue to be decided is whether the petitioners, the disqualification of the petitioner's technical bid for the 6th, you to, no, in terms of the 6 reasons given by the technical committee was justified or not would have to be seen on the basis of the terms and conditions of the tender vis-a-vis the documents that have been uploaded by the petition. Next start. submission of the counsel for the party with regard to the six reasons given by the state responsible for disqualifying the petitions with are being considered herein below as follows. Roman one. Inverted commas and in bold, you write, bidder did not submit average annual turnover for FY to 2023-24. Next para, sub-para. In this regard, clause 19 of the, what is this clause 19 of the bid document?
Bid document.
Clause 19 of the bid document. No, clause
That is the
nine-
NI.
no, cannot be clause 19. Clause 19 of the buyer added, buyer added bid specific terms and conditions. Okay. Of the bid document. Okay. States as follows. That is at page 191. Okay, para this 90. Okay. So, the learned edition is subject that the petitioner has submitted the certified audited balance sheet of the relevant period and the certificate from the chartered accountant indicating the turnover details for the relevant period. And had uploaded, it's not submitted, had uploaded. And as such, the rejection of the petitioner technical bid on this count was not sustainable, correct? Then, next paragraph. Now, Roman two. Clause 12 of the okay, clause 12. Sub clause 12 of clause 4 of the JICA funded procurement of the bid document provides that for page 196. It is attempted. It says, well, then to stop, then you write, invert comma, service and support added, ADDED. Dot dot, bidder should have skilled and trained service engineer based at a time. Invert comma, page 190. Wait. The technical committee has held that invert commas, the invert commas bidder, from bidder into his person. Bidder did not submit details of skilled and trained service engineer based at a time. Yes, sir. In relation to, in respect of the above, comma, the learned Standing Council for the Health Department has submitted that the a clarification has been sought for from the petitioner with regard to the petitioner not having submitted any documents to show that he had a skilled and trained service engineer based at the time, comma, the to which the petitioner had submitted letter dated 24/2/2025, comma, addressed to the Director of Medical Education, comma, Health and Family Welfare Department. Okay, okay,
So clarification was 11/2. Then it was not asked.
okay, it was not right. Whatever, in this respect, the learned, Standing Council for the Health Department submit that the petitioner did not submit, did not upload. No, but the petitioner had uploaded a document showing various skilled and trained service engineers for service and support added, for service and support of the machine to be procured by the department. However, the document submitted by the petitioner did not indicate that any of the skilled and trained service engineers therein were based in a cell. However, the petitioner had subsequently written a letter after the last date of submission of it. That is on 29/1/2025. They have the letter dated 24/2/25. Huh? That is after the last date of submission. Which is to the following effect. Inverted commas, page 222. We hereby confirm that we do have skilled and trained service engineer based at Assam to meet up any types of technical service support on time. The details are given below. Details. Okay. I'm just marking you something. Here. No, continue. The Council for the Health Department submit that the above letter clearly prove the fact that the petitioner with documents did not contain the name of any skilled and trained service engineer based at the time. Prior to the last date of opening of the last date of submission of the bill. As such, there was no infirmity with the rejection of the petitioner technical bill on this point. Next para, sub-para. On the other hand, Mr. A. Sharma, the learned counsel for the petition, no clarification on this call had been asked for by the respondent. And the clarification that have been asked for Right, email dated 11/2/2025 was on different issues as has already been provided in the said email. We accordingly submit that there was no occasion for the petition to make a clarification on the said issue. However, the petitioner had submitted a list of engineers submitted submitted a list of skilled and trained service engineers. And one among them, that is Parthajeet Sharma, at serial number 8 of the set list, was the innocent. That particular page was the defendant. Now, Parthajeet Sharma is the senior sales executive, not an engineer. Page triple two, no, that is from Mr. PP Data. No, no. Here. Okay, next, there's a full stop, huh? Then subpara. Mr. P. Gogoi, submit that Parthajeet, they submit that the list of the skilled and trained service engineers provided by the petitioner does not indicate that any of them were from Assam. Further, the serial number 8, Mr. Parthajeet Sharma, was not a skilled and trained service engineer, but was the senior sales executive as per his designation given in the list by the petitioner. Next. The third ground for rejection of the petitioner's technical bill. Now, don't say that. It was inverted commas, kept bold, bidder slash OEM did not submit past experience document. Ah. Then, inverted commas close, next para. Clause 2 and 4 of the NIT provide that form. Page 184. Take it out. This one. Okay.
Page 191.
Clause, then next para, clause 30 of the buyer added with specific terms and conditions of the NIT states as follows, page 192. And whatever it is, clause 30, no? So that is a page 192 bottom, So out here, your case was what? That he only sells,
Verified that actually they have supplied. So they have submitted a tax income, but by the 4 trillion people of the one.
procuring authority.
Procuring authority.
Okay, right. Mr. B. Gogoi, the standing counsel for the health department submitted. The petitioner only submitted tax invoice to prove that he had the experience.
Point. The contract paper along with the
Submitted that, submit that the petitioner had submitted the
contract copy.
contract copy and the tax invoice.
No,
And the
contract copy along with the invoice,
contract copy along with the invoice,
which is self-attested.
which was self-attested, to show that he had the experience criteria.
My argument will be that is the requirement under law. Law 30, law 50, that is
Which
extra
was not. No, full stop, full stop. Which was it? He submits that. There was no document, like certificate issued by the procuring authority to show the experience slash performance criteria of the petition. On the other hand, this. On the other hand, Mr. A. Sharma submits that there was no requirement for the procuring authority to submit, to issue any experience criteria certificate or past performance certificate in respect of the supply undertaken by the petitioner,
from the procuring authority.
from the procuring.
What is required was the contract copy along with the invoice. And it is the
Just what is there. So far as we found for it, like, the 3 months. So what to take up
This,
what to make idea when you said, my God, sir. Yes. Slide number 1. Then the third page from there. First is the contract, second is the invoice, the next contract. Yes. What you see down below of the page. Specification, sub-specification. They have subsequent method, what was the specification of the product supply? Whether it tallies with the present method product in tender. No document, it's only one page is not the complete form.
where is
The third page.
this page, this green, this is one.
One, then the next page, the
Two.
invoice, then the third year. Yes, it's the contract method. Protein is down below of the,
Yes, product specification.
there, nothing is there, but that part is not confused. Same way, madam. After the tax invoice again, madam, specification, first specification, nothing has been given. This is the given the complete contract. To see whether the same product, because they have various products, like I, there is a product that is supplied. Whether that same product was supplied or something else. And while seeking for clarification, they submitted the same.
So the experience certificate is with regard to
That's why
similar product,
Very proud.
correct?
That is a similar product. That is the what? Document. Finally, if you say, but the same document of finance. So what that has to do with it? 300 down below. No, look at this, look at this.
MSL cardiac monitor 338.
No, not 330.
And the invoice also refers to that those cardiac monitor. 69 is required, 50% of 69 is required. We are going to be at 38. So, see, the invoice also refers to that same cardiac monitor. Now, that is by expert garden council for other side. So these are not the ground. They say documents not submitted. Not simply appreciate.
Anyway, look, we're not ending the matter today.
These are the documents that.
We are hurrying it up because you have to go to Arunachal.
That's okay.
So there's no point going too far.
Going by.
we-
the reference.
No, you can make this argument later on. Whatever I just said. Now, before on the other hand, you just said, Mr. B. Gogoi further submit that there is nothing to show in the invoice submitted by the petitioner that he had submitted a similar type of
Similar type of product.
product earlier.
Yes.
Full stop. Next para. On the other hand, Mr. B. Sharma submit A. Sharma submit that the
The ground taken
That
by the
the-
project is on submission of the document. And that has to be.
submits that the ground taken by the technical committee for disqualifying the petitioner is that
I did not
the-
submit.
a petitioner did not submit past experience document. So the same has however been submitted. And
Contract paper.
the respondents are only trying to pick holes on the merit of the past experience document submitted by the petitioner.
Why I say so? Otherwise, they would have rejected me on the ground by saying certificate submitted.
He
but
submit,
found to be
he submit
not
that,
valid.
that the issue of whether the past experience document submitted by the petitioner has merit or not is not the issue to be decided. And the only issue that was required to be decided was whether the petitioner had submitted past experience document. That's all.
And the admission is documents have been submitted. But
Okay.
now they're trying to find fault with that, which is not a part of the bid evaluation.
We also submit that the submission
It's
of
not
the
used to-
Learned Standing Council for the Health Department clearly shows that there is an admission by the state respondents that the petitioner had submitted the past experience document
by way of a
to
contract.
stop. However, the same was not up to the, not up to the standard required by the respondent authority.
Is the submission
As,
made today?
as the petitioner had not, as the petitioner document was allegedly verified of the fact that he did not supply similar product earlier. Mr. Sharma submit that careful perusal of the invoice would show that the petitioner had supplied similar product, the exact similar product earlier.
And my ground of rejection is not that, the contract.
Anyway, enough.
No, the ground of-
Going round and round the tree is enough. How many times will you go around? You see a Hindi movie, there's a dancing around the tree once. Enough.
doing as far as possible for my client something. I'm trying to do my duty for the client. Because by looking at the papers, I also understand.
Then we are going to have another chance to argue on another date. Wasting time. Next para. Next para. The third ground, huh? Third ground, fourth ground. Okay, wait, huh? Fourth ground is for next Roman fourth. Bidder did not submit EU certificate. Okay, EU certificate. So stop. Next para. Page 187. Both sides are trying very hard.
Towards the last portion of the bid.
Huh?
Is it certificate?
Right.
Yes, sir. Bid document. Of the bid document, that's towards the last pen.
What?
Of the bid document that has.
Wait, let me do it as I know it.
Yes.
Peter, why you still here? You go. It'll be Roman 4, no?
In our reply, we have an Excel.
Okay, Roman 4. Bidder did, in bold, huh? In bold. And in inverted commas. Bidder did not submit EU certificate. Okay, now next para. Mr. P. Gogoi, no. Yes, Mr. P. Gogoi. Submits that the above pertains to the technical specification required of the product to be supplied, and especially with regard to the additional specification parameters, that is inverted commas, certification required, dot, US, FDA or EU, CE, bracket 4-digit notified. Page 187 at the bottom. Correct. Page 187. Next one. Mr. P, next para, Mr. P, go over. Submit. That the certificate that has been submitted by the petitioner had expired on 27/5/2020. That is before the opening of, before the submission of the petitioner's signature. As such, the petitioner's bid document had violated the terms and conditions of the right. On the other hand, Mr. A. Sharma, last officer for the petition, submit,
332A.
huh?
Next page, 332A, with the action.
332.
230. 230. Is the one of that certificate required?
I know.
And the next page is the section. You also will see the model in the certificate, vital wave. At page 232, the model, vital wave,
No, no, where is that, submit?
232A.
Submit. That, though the certificate had expired on 27/5/2024. The petitioner had applied for what? For revalidating or what? For extending the validity,
For extending the value.
for extending the validity of the certificate. However, during the period for which there is the period between the expired, during the period between the expiry period and the actual extension, the actual issuance of the extended certificate. Transition timeline are provided by the concerned
Certifying authority,
certifying authority,
MTIC, inter,
that is MPIC INTERCER, INTERCR,
that page 233, bullet number 3,
which provides,
bullet point number 3.
which provided that the products manufactured by them
And the class 2B, right,
under class 2B, small b devices.
are extended in 31st December 8.
What was extended? The validity or the certification?
The
The certification of the device, the certification of the class 2B devices was extended up to 31/12/2020.
and class 2B is vital wave, not will find the next thing.
He submit that class 2B
Refers to the model
refers
vital
to
wave.
the product that is to be supplied by the tenderers, that is model
Vital wave.
vital wire, VITALWAVE. So
We cannot be paid to get expired certificate.
he does submit that the certificate submitted by the petitioner cannot be said to be expired certificate. So, next one. In bold, you write. Inverted commas, bidder did not submit financial standing certificate. Mr. B, go away. Submit that the said reason refers to clause C of the buyer added bid specific terms and conditions of the NIT, which provides as follows, page 189. The Learned Standing Council, submit them. The petitioner. Yes, but the petitioner did not submit what?
My case is,
No, yours case I don't want.
One of the ground that is.
financial standing certificate.
Certificate of. Standing is that one of that.
Huh?
One of the bank financial standing certificate has not been furnished. By the bidder, that is our step. Of that particular clause.
But then that is referred to this clause 3, the other. That,
Yeah, but it-
the submit that the petitioner did not submit. The financial standing certificate. On the other hand, Mr. A. Sharma submits that a bidder was not required to submit a financial standing certificate in as much as the bidder was only to upload an undertaking to the effect that the bidder was not under liquidation on a court reserve, receivership or similar proceeding and should not be banked. The petitioner's undertaking that has been submitted along with a bid document will that
In the document, I am holding the bid document. Let me tell you. So it is there. In our reply page. Sorry, reply page. Not denied. This is the undertaking as before as the clause, and we have given. Yes, to the
undertaking it is 26/1/2025. The what which has been submitted along with it. States as follows. Okay. Page 260. Okay. Next paragraph. Roman 6, inverted commas, bold, bidder did not submit declaration on spare part availability. Next paragraph. Mr. B. Over the learned standing counsel for the health department, submit that the fifth reason, which is ground for disqualifying the petitioner technical fit relates to clause 8, only 8, huh? Only 8, clause 8 of the special terms and conditions that version dot 2 of the NIT, which states as follows, page 188. Okay. Mr. B was submitted that the petitioner had not provided materials, information, etc. pertaining to the spare parts manufactured and supplied by the OEM. He submits that the petitioner had only made a list of spare parts which could be supplied by the OEM. OEM means? By the OEM without providing any material or information regarding this. On the other hand, Mr. A. Sharma, the Senate Counsel for the respondent number, no, for the petitioner, submits number 6.
The list itself provides for the spare part. The list that has been just now presented at the other side. That is what is different. And along with that, the undertaking was also given as per clause 8. That is
So the information and he says that the information is required.
Yes, information is in given.
Information and material.
They'll
Provide material and information.
So it has to now, if we have to understand material from the point of view of physical material, then it has to be the samples, spare part samples,
Okay, what about information?
information that list we have given already. That list that he has already pointed
Let
out.
us see something.
Is 180 again.
On it is there.
Sellers will provide material, less information, etc. pertaining to the spare part, not the spare part system.
No, I will see. Let me decide that.
No, as a way of explaining matter.
What is one?
Yeah.
No, but he's saying that,
Provide
okay,
the spare
where is the list?
of, standard document. That matter escalation metric prior to that matter. Yes. Yes, yes,
Prior to escalation metric.
yes. Seven. There's a full number. List of spare parts, accessories, material.
Okay, list of paper. What do I say? That the list of spare parts, the list of spare parts provided by the petitioner by letter dated 23/1/2025
It's the requirement at the top.
meets the requirement under clause 8 of the special terms and conditions dash version .2 of the NI.
So saying non-sufficient is not correct. And additionally, we have also given an undertaking regarding availability of spare parts at place 286 along with the bill. Additionally, we have given
Additionally, the petitioner has given a
an
list of an undertaking
regarding the availability of.
regarding the availability of spare parts.
For 10 years, for 10 years.
What are they?
But then the ground of rejection is not shortcoming. Ground of rejection is, I have not submitted at all. But now the thing is, it's been submitted. And they are finding shortcomings in that list. The difference is, documents not submitted, but documents submitted, but I don't find very similar documents, but for different aspects of.
Anyway, anyway.
And
So I have heard you, except from Mr. PP there. So when are you going to Arunachal?
now,
Now, I can hear him and I can picture this. Ah,
I'll be there.
yes, I think we have written what we have got to them.
Let me also have a, therefore,
Yes, yes.
what these arguments are.
Correct, yeah, you will want to counter it also.
On 19th,
Huh?
on 19th, I think, 19th.
Yes, 90
Just develop for some people that will say. So my team, I can say.
Yes, everyone. I'm just,
The question.
because he wanted to go, so that's why I was in a hurry to, record, otherwise it will again take time to understand.
I'm obliged, doctor, given me so much of time in this.
Did I have a choice?
I get it.
2 points. Yeah, you sure? That I can go. I got somebody else.
So for it, there are two conditions, okay? Getting the CS certificate.
What certificate?
Chartered accountant certificate. In respect of showing the annual turnover. And is past performance. For it,
Is
past performance.
pass performance. Okay, one is CA certificate.
CS certificate. Totally the annual turnover.
And number 2 is
Number two is the past performance, the document which he has submitted. So that, I would again like to draw your attention to page 184. That was when that minimum annual expenditure.
Yes.
The minimum, that is clause 1. The minimum average annual turnover of the bidder during the last 3 years, ending on 31st March of the previous financial year, is years indicated above in the bid document. Documented evidence in the form of certified audited balance sheet of the relevant year or a certificate from a chartered accountant, cost accountant indicating the turnover details for the relevant year can be up to date with the bid. In case of death of completion, recuperation of pay less than 3 years, the average annual turnover in respect to the completed financial year after the date of completion shall be taken into the account to the criteria. So, this argument is that in view of the certificate of the chartered accountant, the annual turnover, annual balance sheet, audited balance sheet is also sufficient. Yes, sir. But annual balance sheet, which the petitioner plan is submitted, will have to show that his last annual turnover. Which is right. For that logic, the annual page 212 logic. Of, no, okay. I'm relying that affidavit in opposition, as all are relying on that affidavit.
Affidavit of two.
Logic. Page
I can find only four.
212 logic. 212 common affidavit and department. The petitioner is also projecting his form with affidavit, so I am also relying that.
This is affidavit of point number 4.
Yes, sir.
You said two.
No, sir. 212.
212.
Page,
Okay, yes.
page 212. What you got it?
Yes.
But this is the annual turnover showing the financial year of 2020, 21, 2020, 21, 22, and 22, 23. As per the requirement, he has submitted
24.
24, which is page 211A. He has the requirement certificate as annexed 211A. So the previous page.
Yes.
Yes.
211A. Yes.
So this why I am relying on page 212 is that the average annual turnover loss to good fine for the financial year 2020-21
22.
is 30,
33.
yes, 33 crore 4 lakh 58,000.
Ah.
This has been verified in the audited balance sheet for the good fine as page 214.
Yes.
214, the last book column was the first figure.
Yes.
That is 33 lakh 4 lakh 58,559.80. This is the
Where do you get?
average
No, no, where? 21?
214.
4.
Four. That first figure was the
Yes.
that's the amount. 33 crore 4 lakh 58,589.80.
Just a minute.
And that is the
Just a
annual
minute. Just a
turnover.
minute. There is 214A, 214, 213A. That this A thing is,
Yes.
was confusing me. Okay.
214 figure is also the average annual turnover, which is reflected in page 212.
212 is 3304 for 2021.
This
Ah.
figure is reflected in the audited balance sheet.
Ah.
Next logic, kindly come to,
So what do you want to show?
yes, logic. Now, let's come to page 212, next financial year 2021-22. The figure is there, 47 crore 2 lakh 93,190.10. For that logic would come, page 216. A.
Two and six A.
A.
Ah.
Lordship, that same figure, Lordship, will forget Lordship at on top of later, 47.
Yes.
And now Lordship, for the financial year 2022-23, as per page 212,
Yes.
Lordship would sign page 218.
Yes. Two one eight against six seven. Where is that? That is not there.
Yes. But that, for that financial year, Lordship, 2022-23 and 23 and 24. In the audited balance sheet, that figure is missing.
2022-23 is not here, it's page 2
Page 214. And no other page is also annexed. And for the same requirement in 2023 and 24 also, they have not submitted that particular that audited balance sheet. How can a department would accept that audited balance sheet in lieu of chartered accountant certificate? These are lost factors, which I have mentioned in my affidavit also. They have not had it. And second thing,
So that figure is missing.
that figure is
27 lakhs is missing.
the figure of annual turnover for the year 2022 and 23 and 23 and 24 are missing in the audited balance.
That is missing. 22, 23, 24 are missing.
Are missing.
But 22, 23 of the figure is not there.
Yeah.
The figure at page 212 is not there in 218.
Not the one.
Is it there in 218A?
Yes. 188 is there. They have not annexed to particular page.
Either we
How-
have not annexed or it is not in the affidavit, I have to verify.
No, they have been not annexed.
Tender documents, I have.
They have the document.
The pin.
You have to see the
Yes,
because
yes,
if it is there.
Kindly verify. It is the first download. And second thing, Lordship, is Lordship.
CS certificates are there.
That yes, that is the-
Page 211A. Page 211A. And 212. 211A.
But what is the requirement?
there's no thickness.
Either the audited balance sheet, audited reports, or the CS certificate indicating the same. Now, we have given both of them. Now, this document was found faulted with because the address into whom we had addressed is a different address. This is Assam Medical Service Corporation Limited. But that does not discount the fact of my financial status. The only the address to whom it has been given by the CA, that is wrong. No, I'm not arguing on that. What I'm saying is,
And no thickness.
my data, my financial standing will not change.
That is up to you. It is not with regard to the, it's a different issue.
And so,
Signature is the UPI something.
So 211 is, this cannot be pressed into service.
What I am saying is, audited balance sheet, audited document, I will verify. If it is not been annexed in the affidavit or it is also not there in the bid document. But leaving that aspect aside, what I'm trying to say is the financial status that I have, I command, is also evident from these two CS certificates. The only fault that has been found in the CS certificate is that the one to whom it has been addressed, the certificate to whom it is addressed is different. But that does not changes my financial status as certified by a CA for that particular year. That is my argument. I admit the one who has addressed is wrong. I might have been a mistake, if I may say so. But then it does not changes my financial status as certified by a CA. So the financial status is not changed. Just because the addressee to whom it has been addressed is different. Because what they are doing is they are assessing my capability on the financial aspect. So my capability does not change.
But when you give your profit and loss account,
Yes,
and when your documents do not match,
that I will have to verify. That I will verify. Because this is a trading account. What I have seen for the other 2 years,
You know what you've got to look into now.
Yes.
Well, let us hear his other case.
Now,
This is,
I'll clarify on the next video.
now regarding the experience criteria, Lordship, the page 184 again, Lordship.
184.
It's already read out, but it's experience criteria. That clause 2 and 4 has to be read.
Yes.
Experience criteria. In aspect of the filter applied for experience criteria, the bidder or its OEM themselves or through retailer should have regularly manufactured and supplied same or similar category products to any central state government organization, CSO, or number of the financial year as indicated above in the bid document. Before the bid opening date, copy of relevant contract is important to be submitted along with the bid in support of having supplied some quantity during each of the financial year. In case bunch of it, the category of primary products having highest level should be meet the criteria. Not four, bunch of products. The bidder or OEM should have supplied same or similar category products for 50% of the bid quantity in in at least one of the last 3 financial year before the bid opening date to any central state government employee copies of relevant contracts providing supply of food to the controller. So the entire contract document will have to be submitted. What he has submitted was this. But to get this document to find page 222A. 222A. The part. The first page of it. New. The contact was the top was the right hand product. The contact number was the same number is given here. And generated date is 24 January 2022. And
Yeah.
and it was saying of the railway. Here, Lotte would see. So that he'll have to apply same or similar product at least 50% of that quantity. And the same or similar quantity will have to be come from the bid document. There is a specification of that product which is required to be supplied by the bidder. That's page 185.
Yeah.
That is the logic cardiac monitor with defibrillator. 69 feet. The specification, standards, performance parameter, first capability parameter
No,
of
no, just a minute. Page 185.
185.
59 feet.
These are the specifications. What are the products still required to be supplied? The first, the capability parameter of the defibrillator. ECG monitoring, right hand side lordship, external defibrillation, external pacing, internal defibrillation, and recording. These are the major parameters. And lordship will find in next page, one of the major parameter lordship, page 186. Okay. ECG monitoring and facility for internal defibrillation. Okay, got it?
Yes.
Page 186.
Yeah.
Number 8 plus 8 for roll lordship.
Yes.
Facility for internal defibrillation. Yes. Okay, got it? Page 186.
Provision for stainless steel probably.
No, just above lordship, facility.
Facility for internal
Defibrillator, yes. That parameter is required to be supplied in that supplied material. Because of this cardiac monitor is to code up patient with pacemaker and heart patient in the ICU. That internal defibrillation is a major component. That is my information. Now, the petitioner has annexed the contact document without any specification at page 222A.
Yes,
Till only the first page has been enacted.
I can't read my pocket.
That page in,
Here is very good copy, okay.
that first page. Same thing, Lordship.
Okay, yes.
Only first page has been annexed. Next two, three pages he has not annexed. Why I not, has not annexed, I will come back. In second also Lordship, next page Lordship, that invoice, I am not commenting. And next contract Lordship, of page 2 to 3A. It was a contract Lordship supplied to the railway, generated in 18 July 2022. The same contract. What you got it?
Yes.
Yes. Herein also only one page, first page is connect. The last Lordship row, specification.
Yes.
There is a continuation Lordship. They have not submitted those Lordship before the authority. Why Lordship? But may kindly come to my affidavit also. Another contract document Lordship he has submitted at page 2 to 4A also.
Two, four, three.
A Lordship. Because of 25th November 2022. 26th November 2022.
Yes.
Here, Lordship, only the one page has been annexed. Now, Lordship, I think my affidavit in opposition, Lordship, I have filed. Lordship, my affidavit for opposition, file on behalf of F1 number 7, we find it. Can of Lordship, page, start from C11. Lordship, page C22, relevant. Lordship, this is the contract agreement, contract Lordship, to which he has realized Lordship first. I have annexed his specification Lordship. Page C23 Lordship. Lordship will sign it page C24. The specification, the fourth row.
Yes.
Facility for internal defibrillation,
24.
page C24.
Yes.
And the row number 4, fourth row.
Ah,
Facility for internal defibrillation.
yes.
Right hand column no. Whereas the requirement as per 185 specification, facility for internal defibrillation, yes. Employer is requirement of having facility of internal defibrillation, but his contract with my learned and client has annexed has no facility for internal defibrillation. How it could be same and similar? That's why Lordship, he has suppressed, they have suppressed that other part of the contract agreement. That yes. And the second Lordship, page C27. The next contract which we have Lordship annexed.
Yes.
Here also on the first page has been annexed, and I have annexed the entire document Lordship. Here also there is no facility for internal defibrillation Lordship. Similar Lordship,
Yes, sir. Ah,
page C28,
328.
C28, second contract submitted by him. 8 row from the bottom Lordship.
Yes.
Facility for internal depreciation, no. If
Huh?
earlier,
Oh,
8 row from the left, is T28.
1, 2, 3, 4, 5, 6, 7, 8. Maximum energy selection on two.
No, no, page to T28. T28,
28 of course.
T28. 8 row from the bottom left.
Oh, from the bottom.
Bottom left.
Ha.
Here, there is no facility for internal depreciation.
But what about what about the 22A and 23, 223?
He are the same contract. He has not submitted the NHR specifically as a part of that contract agreement.
Okay,
Because of this.
no. So 22A is 324 or what?
Yes.
22A is 324.
Yes.
And 223A is
T27.
327. And 328, so it's separate. 224A,
Yes.
that is 328. Is it?
Yes, sir. And that them contract is 26 November 2022.
Huh?
And another contract will be submitted.
That is?
Is that 224A.
224A, I've already said.
Sorry, Lordship. 223A is just I have.
You see, 22A, 222A is 324. Correct? I think you should read a small chart.
Yes. Lordship, 22A is related to 222A related to page T22.
322.
T22.
Oh, 322. And then
223A relates to Lordship 227.
327.
Sorry, T27. And 224A relates to TC1.
331.
TC1 Lordship.
And 324 relates to what?
T24 relates to is 225A.
Okay, 225A.
Yeah.
And what about 328?
T28 plus 3. So there is also no facility for internal depreciation. 8 row from the.
No. You have submitted 328 in your affidavit.
Yes.
328 relates to what document?
T28, the initial page, first page is T27.
Acha, 327, 328, same thing. Okay.
T28 other specification.
Okay, so 327, 328 are connected.
Is correct. And next, contact is TC1.
331 is relates to
224A.
224.
Yeah.
224.
Yeah. Here also, proceed in 11 page TC2, wherein that facility for internal depreciation is no.
Where is that? Ah, yes, at the bottom. See, bottom two.
Supplier, we are going to supply a very sensitive and delicate machine of keeping the heart patient and cardiac patient. If they are submitting this type of document logic, how can the employer will decide? And it is the authority to decide whether it would be acceptable or not. It's my. But we have already passed authority in this way. I thought. That's not possible. So we has already claimed that part of NP Supreme Court judgment happened on 19. And these are not
out of a multiple number of internal specifications, it picks up one internal defibrillation and says that I have not supplied machinery in meeting that particular criteria. What is the experience criteria? It says same or similar category. I have submitted similar category. That's my argument. It says same or similar. It's only one thing that he's referring to, internal defibrillation, regarding which neither any one of us know how important that is. But the machine that we have submitted is not.
Seems very important the way he said it.
Yes, that's what I'm saying, according to him, but we actually don't know, anyone doesn't know how important that is. But my one point answer to that is,
Only you know.
I also don't, I don't know what the machine is altogether. But the answer is same and similar. They cannot deny that what I have submitted.
So anyway, you find out, since he has got out, this whole thing is. Yes, everyone, I think you all have heard each other. So you all know now which points to take care of.
Same or similar. So if it is not same, at least similar, I cannot respond on that aspect. That it is similar. They have not rejected my product. Product is approved. But then they rejected me on the other ground, which now they are saying, yes, it is there, but yes, the document does not meet their standard. This is an argument made before the Honorable Court and it's not reflected in the Tender Evaluation Committee's assessment report. That is where your logic will have to test that. They're all arguments, they're not here. But the assessment is 1 point assessment. It says documents not submitted. It does not say documents submitted, but the contract paper is not sufficiently, it does not reveal everything. That's it. Documents not submitted. So today the documents are there. Losses also, these are admissions also coming from the other documents are there. But they say this document does not meet that criteria or that criteria for 19.
Right. Mr. PP Datta. Learned counsel for the respondent number 7. Submit. That in terms of the terms of clause 1 of the MFDNIT, which requires a bidder to submit the minimum average annual financial turnover during the last 3 years ending 31st March of the previous financial year. Documentary evidence in the form of certified audited balance of relevant period or a certificate from the chartered accountant that cost accountant indicating the turnover details for the relevant period was to be uploaded in the bill. He submits that the annual turnover statement of the petitioner as annexed to the writ petition would go to show that the petitioner has given information certified by a chartered accountant for the financial years 2020-21, 2021-20 and 2022-2020, which are as follows. Just take it out at page 212, chart. Next one. Mr. PP Datta submit that though the petitioner huh? Uh, whatever. No, for example, before, as an next, which has been provided. By way of two documents. Comma, one being addressed to the Managing Director, Assam Medical Services Corporation Limited. And the other. Have I given the date? No. Huh? Dated, dated, what is the date? No date. Page 211 A is no date. Dated nil, huh? Dated nil.
Put up.
I thought so. Dated 26th of 2024. And the annual turnover statement dated 31/10/2023. Are reproduced there in a, huh? So you take the first one first, 211. Okay, huh? Here to. Okay. That's one. Oh, next. The petitioners, no, the council for the response number 7, subject. That with respect to the financial year 2020-21. The petitioner had also submitted his trading account for the year ending 31st March 2021, which shows that the amount of rupees 33,04,58,58. Similarly, the trading account for the year ending, no, for the financial year 2021-2020 shows the amount of rupees 47,02,93,19. However, the profit and account loss for the year 2022-2023 does not show the average annual turnover of rupees. That does not show the amount of rupees 27,03,0650.8. We also submit that the average annual turnover for the year 2021-2022. For the year 2023-24 has not been submitted. By the petition. Yes, sir. It's the PP that also submitted. That in terms of clause 2 and 4 of the NIT, which requires the bidder to submit his experience criteria and performance and past performance. The bidder was to submit, was to show that he had supplied same or similar category of product for 50% of the bid quantity. In this respect, he has relied upon He submits that, this is correct, he submits that. The petitioners con- uh, contract, with it, past contract and the invoice submitted by him was incomplete. And the completed invoice as provided in the, and the completed invoice of the petitioner as provided in the affidavit in reply. Huh? An affidavit in position filed by the respondent number 7 goes to show that the product to be supplied by the petitioner was different from the product to be supplied from the product that had been supplied earlier. In as much as the invoice submitted by the petitioner, invoices submitted by the petitioner did not show that the past product supplied by the petitioner had the facility for internal DEBI, no, DEFI, BRILLATION. While spell the NIT, it requires that is it. Where, that,
Page 186 of it.
while,
180.
while. The specification and capability parameter of the defibrillator that has to be supplied requires that it should have the facility for internal defibrillation. Huh? That's all.
Yes, not connect the specification part of the subject.
So Sabir also submits that the petitioner has not submitted the specification part of the contract. Of the contract? For which contract? The specification part of the past contract
To indicate my path.
to indicate his past experience in supplying the similar type of same or similar type of uh, uh, cardio. What is that?
Cardio monitor.
Cardio,
Cardiac monitor.
cardiac monitor. Huh? Cardiac, cardiac monitor with defibrillator. Huh? On the other hand, Mr. A. Sharma submits that the petitioner has supplied a similar product in terms of the energy, the similar product.
The record, which is the quantity for the NI.
Which
Well,
is the
it says
condition
same or
as
similar.
per the energy. But 186 says that specifically internal.
Here, the product that I have supplied now has this. This they're talking about the past experience. The product under consideration has internal effect.
What have I said? Okay.
On that aspect, there is no difference.
And that he would be supplying a cardiac sensor having internal defibrillator
That's
facility.
the part of the question only. They have accepted that. Regarding past experience, they are saying similar.
Okay, right.
Same items I have not supplied.
That's all, that's all. This is the matter on 90. As Parker. Huh? Oh, I should give it Parker. Better let him, I think. Yes, policy already prepared today. Already be there with the online already. It has to be separate account. We can take it up at two. Also,
Some
let
places arguments are already done, we now the clarity.
clarifications have to be made, their citations have to be produced. But don't bring too many citations, hardly any, there is no law out here, I think. There's no law involved,
Basically all factual.
all factual
Factually.
issues. Leave it like that someday.
Yeah.
I don't know. I'm scared of this partner business now because it follows you around wherever you are. Anyway, okay, right, partner.
Can I also take the liberty of submitting a compilation? Because what is now seems is, because the documents are here and there. I am saying that this document is here, and they are saying no. If I can just compile everything as to what they are saying is not there, and I say it is there, and paginate it, probably it will be easier to,
How many copies are you going to make?
for all of us. That is already with me, but then let me paginate it,
Index.
index it, and also give a para-wise thing that this is the argument, that this is the document, page number to it. Just,
But I'm not going to follow arguments. I've written so much. I cannot change my.
no, not an argument, to indicate where the pages are. They say not there, I say. it is
Don't
there.
don't put any written arguments now.
Not an argument, not an argument. Just that page. And I will still be maintaining my argument that logic will have to test the evaluation, right? The evaluation as is there in that particular evaluation decision making process. They are saying documents are not. Now they are saying documents are there. So that means they, at the point of time, there was a fault where the evaluation took place. And the evaluation committee did not do the work as is required to be done by them. They are not saying documents is not there. They are saying documents are not there. But today it is now that documents are there. Applicant is the documents are there. But looking at the documents, it does not lead to a very trustworthy sort of a document. But then that is not the ground which was taken by tender evaluation committee while rejecting by them. Therefore, on that aspect, also will have to test that. And they say contract paper submitted, but it does not indicate the product that is required, and therefore on that count is rejected very well. They say document not submitted, spare part not submitted, EU certificate not submitted, financial documents not submitted, something of that sort. They are specifically saying documents not submitted. They have never said documents submitted, documents not found to be valid. That is not their assessment. So this is something that they are now supplementing and developing before this order, which is not there in the document, the record of the order.
Tell me why you planning to go now by road? You're planning to.
By road, I always travel by road.
Why don't you take the night train first?
Once I reach there, I become a bit handicapped thereafter. From the railway station, the hotel and to the this thing.
You tell them about train GP to buy or oil India
India.
to
They don't
provide
do
you.
that. They don't. They say you are young, go.
So they'll be giving you taxi money, everything.
It is true, but I prefer taking my own vehicle, and then I will ask for reimbursement. That way I'm protected. And as it will be a road trip for me also. With two juniors, I'll go. for road trip.
I just went the other week.
Yeah, the road is very nice.
But then you've got to really drive fast and it's not a very relaxed journey. As a lawyer, so you can relax. Don't even have to reach Nahar Lagoon.
I just have to be there in court by 10:30 tomorrow. That'll be it. Obliged, Vilod.
Yet, all we put applies for the as well. So the formula that was used, he says that it should be calculated on its contract demand and not on its connected. The formula provided for connected. So
Yeah, vaguely.
that is the
Possible, I don't think, but have it on an app. I don't think, we'll finish. Yeah. After that. Right, on the prayer, the party is the math after.